Senate will come back to order. 2 o'clock, March 22nd. House bills on first reading. Introduction to House bills. House Bill 165, first reading of the bill.
House Bill 165, Wyoming's Tomorrow Scholarship Program, sponsored by Representative Harshman. Passed the House, ayes 44, noes 16.
House Bill 165 is assigned to Committee Number 4, Education. House Bill 166, first reading of the bill.
House Bill 166, engrossed, Utilities Presumption Against Early Facilities Retirements, sponsored by Representative Harshman. Passed the House, ayes 49, noes 10, excused 1.
House Bill 166 is assigned to Committee Number 9, Minerals. House Bill 190, first reading of the bill.
House Bill 190, engrossed, Vehicle Titles for Non-Resident Owners, sponsored by Representative Brown. Passed the House, ayes 58, noes 2.
House Bill 190 is assigned to Committee Number 8, Transportation. House Bill 207, first reading of the bill.
House Bill 207, Coal-Fired Generation Facility Closures Litigation Funding, sponsored by Representative Haroldson. Passed the House, ayes 53, noes 7.
House Bill 207 is assigned to Committee Number 9, Minerals. House Bill 217, first reading of the bill.
House Bill 217, engrossed, Community Health Center and Rural Health Clinic Grants, sponsored by Representative Wilson. Passed the House, ayes 53, noes 7.
House Bill 217 is assigned to Committee Number 10, Labor and Health. House Bill 236, first reading of the bill.
House Bill 236, engrossed, Firearms Transactions, Financial Discrimination, sponsored by Representative Washut. Passed the House, ayes 49, noes 11.
House Bill 236 is assigned to Committee Number 1, Judiciary. Reports from standing committees.
March 22, 2021. Mr. President, your Committee Number 1, Judiciary, to whom was referred House Bill 33, engrossed, Interference with Public Contracting. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Kolb, Cost, and Nethercott. No, Senator French. Excused, Senator Cooper. Senator Nethercott, Chairman. March 22, 2021, Mr. President, your Committee Number 1, Judiciary, to whom was referred House Bill 73, engrossed, Birth Certificates, Gestational Agreements. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. February 22, 2021, Mr. President, your Committee Number 2, Appropriations, to whom was referred House Bill 107, engrossed, Retirement System Efficient Disbursement Method. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Kinski, Perkins, and Steinmetz. Excused, Senator Hicks. Senator Perkins, Chairman. March 22, 2021, Mr. President, your Committee Number 2, Appropriations, to whom was referred House Bill 87, engrossed, Provider Recruitment Grant Program. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Kinski, Perkins, and Steinmetz. Excused, Senator Hicks. Senator Perkins, Chairman.
Mr. Majority Floor Leader. Go ahead.
I move the Senate resolve itself into Committee of the Whole.
You've heard the motion. All those in favor say aye. Aye. Opposed, nay. Mr. Pappas, Senator Pappas, you're back in charge of the Senate.
Committee of the Whole will come to order. The first bill for our consideration is Senate File 104. Could I have Senator Landon please come forward?
Senate File 104, would the reading clerk please read the Senate file?
Senate File 104, Anesthesiologist Assistance, an act relating to professions and occupations sponsored by Senator Pappas. It was referred to committee number 10, which returned to committee recommendation that it do pass amended. Ayes, Senators Bouchard, Furphy, Hutchings, McEwen. A conflict, Senator Baldwin. Senator Baldwin, chairman. Was re-referred to committee number 2, which returned to committee recommendation, returned without recommendation. Ayes, Senators Giroux, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, chairman.
You've heard the reading of the bill. What is your pleasure, Senator Baldwin?
Why, thank you, Mr. Chairman. I move that when a committee of the whole rises, they do so with a favorable recommendation on Senate File 104, anesthesiology assistance. There is a standing committee amendment if we can get that read in.
Senate File 104, Standing Committee Amendment number 1, page 26, line 21, delete.
Back to you, Senator Baldwin.
I will move that standing committee amendment and get that out of the way so poor Senator Pappas doesn't have to deal with it. Real simple amendment, floor, is that it just changes the effective date from July of 2021 to moves it to January to enable the Department of Health and the Board of Medicine to go ahead and get all the appropriate things done in licensure, et cetera. We just gave them some more time. They're a little overwhelmed, and it was too short a time period, particularly given the timing of our session this year. So I would encourage your aye vote on that amendment if we can go ahead and discuss
Standing
it.
Committee Amendment number 1 to Senate File 104. Questions? Are you ready for the question? All in favor of the motion to adopt Standing Committee Amendment number 1 to Senate File 104, please say aye. Aye. Any opposed, no. The Standing Committee Amendment has passed. We are back to you, Senator Baldwin.
Thank you, Mr. Chairman. With that approval, I will pass the explanation of the bill and questions on to the good senator.
Senator Pappas.
Thank you, Mr. Chairman. Today I bring before you a licensing bill to licensed anesthesiologist assistants. This is a profession that is not licensed in the state of Wyoming at this time. We've had folks that have gone to anesthesiologist assistant school be able to graduate from these nationally accredited schools and not be able to move back to Wyoming to practice their profession. And so simply this bill is just allowing for the practice in the state. It's a practice bill, very similar to the physician's assistant bill that we did. So this bill will specify the scope of practice. It creates all the required definitions, will identify what the Board of Medicine needs to do to regulate the profession, and provides all the necessary rulemaking and certifications and permits and effective dates, all of that's necessary to stand up a new profession. So what I'll do is take you through the bill. I'm not going to go through page by page. I'll just kind of do section by section. What this does, it creates a new article in Title 33, Chapter 26, Chapter 8 or Article 8. And so you'll see from pages, from the beginning of the page 1 through the bottom of page 5, basically these are all definitions that are required by the Act. But beginning on the bottom of page 5 to the middle of page 11, this is really the meat of the bill. It creates the scope. It identifies which duties and responsibilities are allowed by licensed anesthesiologist assistants, and basically what they can do, what they can't do, and the supervision required for them to do what they do. From the middle of page 11 to through page 13, talks about the Board of Medicine and the powers and duties to license these professionals and to promulgate rules to do so. From page 14 through page 25 deals with all the nuts and bolts. These pages deal with the license application, licensee qualifications, temporary licenses, terms and renewals of licenses, license fees, suspensions, revocations of licenses, and reinstatement and penalties. So all the nuts and bolts, as I said. Page 26, we add some definitions to an earlier section outside of the Act. In section 102, adds definitions identifying the accrediting bodies of this profession. And finally, in section 4, this Act, which was to go into effect July 1st of this year, has now been changed by the by the amendment. And so that was based on the board needing additional time. So let me, that's basically the bill. It's a standard licensure bill. Let me just speak to a little bit about the need for it. Anesthesiologists around the country, there are many states that allow this practice of having assistants assist them during surgery. There are many anesthesiologists, schools of anesthesiology assistants out there that these students go through a pre-med degree prior to going to anesthesiology school. After they graduate from anesthesiology school, they've got to go through hours of clinical training. And then after they are certified AAs, they then can work under the supervision of a anesthesiologist. They will perform the duties required of them, but again, they're always under the supervision. They cannot work on their own. There are others in the state, CRNAs, that do some of the same things, actually identical same things. A lot of folks have told me that you can't, when they're in an operating room situation, they can't tell one professional from the other. Now, the CRNAs do have the ability to work independently under the supervision of the surgeon and not under an anesthesiologist. But this bill will allow a choice. It will allow the practice. Maybe we won't have anesthesiologist assistants here. Maybe we won't. A lot of the folks that have come to me and told me we don't need them because it's economically unfeasible, because you have to hire an anesthesiologist and anesthesiologist assistant. Well, I say let the market drive that. If a hospital feels that hiring one anesthesiologist and a few assistants is the way to go, let them decide that. We should not be deciding the pros and cons of whether it's economically feasible. So also I can tell you there are 17 states out there that allow this. There are a few that do allow a difference in the ratio of assistants to anesthesiologists. The national standard is 1:4, and that's what this bill says. And you'll see in a subsequent amendment that maybe we're seeking to change that. I can tell you that the national standard is 1:4. There's a few states that have varied from that, but that's what this bill allows. One anesthesiologist to be able to supervise 4 assistants. We had testimony from a young woman who grew up in the west part of the state that's graduated from a school. She testified in our committee, and she's working in I guess I can't tell you what city, a big city down south, where they just had some mass shootings. And she would like to come back to Wyoming, but there's no chance for her to come back here because we don't license these professionals here. This is a profession that's duly licensed. CMS, TRICARE, VA, all of these organizations accept the accreditation of the body that accredits these professionals. And I just feel that we as Wyoming citizens should we, as Wyoming legislators, should allow our citizens to have as many options as possible, especially in the healthcare field. And especially in our rural environments. Frankly, in our rural environments, if there's not an anesthesiologist, these folks won't be there. There always has to be an anesthesiologist. So I don't see it really infringing on anyone else's turf. It's just allowing a fair practice in allowing a profession to be able to come to the state and do what they do. And you know, if the market says no, well, the market says no. But we should allow the ability for a professional to come to Wyoming. For that, I would stand for any questions if anybody would like to ask of ask
Questions of
any
the
those.
sponsor, Senate File 104, Senator Baldwin.
Thank you, Mr. Chairman. I just wanted to explain to the body my conflict vote. My significant other, my wife, happens to be the chief opponent or the president of the chief opponents to this bill. And I felt that it was in my best interest probably not to jump into that pool. So I'm not going to throw myself on a sword for this bill, but I will be declaring a conflict.
So Senator, as the late senator from Park County said, the bedroom lobby kicked in on that one.
I'm not going to quote that, but that's, yeah.
Thank you, Senator Baldwin. Questions on 104? We do have a committee of the whole amendment. I'd ask that be read in at this time.
Senate File 104, Committee of the Whole Amendment number 1, page 17, line 3, delete.
Senator Hutchings.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 1 to Senate File 104 and ask for your favorable consideration. I am on and for the bill, but based on the bringer's testimony, I and one of my constituents and an insurance company have just a little bit of concern. And that is, this person is indeed an assistant that is assisting the anesthesiologist. And we were told that they are under supervision of that anesthesiologist and that they're always under the supervision of the anesthesiologist. So with that, on page number 17, line 3, the amendment just states that we would like to change the number that the anesthesiologist supervises from 4 to 2. I just stand and envision the anesthesiologist being in 4 different rooms, no matter how close they are, and one of the assistants having an issue and needing that anesthesiologist to run back to any particular operating table to assist that assistant. So with that, Mr. Chairman, again, I stand for your favorable consideration on the amendment. Thank you.
Discussion, questions on Committee of the Whole Amendment number 1 to Senate File 104. Senator Rothfuss.
Thank you, Mr. Chairman. I'd like to know a little bit more about this before casting my vote. What other states do that have licensed anesthesiologist assistants, whether other states have a range, 2, 3, 4, what those might be, what best practices are considered, and whether the scenario of having 4 anesthesiologist assistants engaged at the same time, it is a scenario that really might take place. Is that something that could happen? In which case, yeah, maybe that's too many. I would assume that if you're overseeing 4 of them, that the probability of them all engaged at the same time would be minimal, and you'd probably also, maybe 2 at the same time would be what you would expect from that. So a little more background. And again, if we are going to pass this, I wouldn't want to position our state as being more regulated or more restrictive than what is considered to be a best practice. But at the same time, if it really does lead to better health outcomes and is safer, I can understand it. So I'm just not convinced yet. If we could have more discussion, if anybody has any experience, if we have any data, any of those things would be great. Thank you.
Before we go to the sponsor of Senate File 104, other questions, discussion? And Senator, you're pointing that direction. Let's go back to Senator Hutchings.
Thank you, Mr. Chairman, and thank you, Senator Pappas. I wanted to kind of give a little background information that I received. It's dated 2018. Colorado, for instance, requests in the past requested direction on those numbers, the ratio by the MDA, and South Carolina is 1-2 was, and Kentucky was 1-2, DC 1-3 normally, and 1-4 in emergency circumstances, and the student AA is 1-2. New Mexico, or the state to the south of us, was 1-3 with enhanced supervision in the first 4 years of practice. Another state to the east of us starts with O, no ratios were required. They had enhanced supervision for the first 4 years of practice. And another state to the southeast of us, student AAs were 1-1, and then I guess they increased it later on to 1-4. Thank you, Mr. Chairman.
Senator Pappas.
Mr. Chairman, you know, I'd like to push back on the amendment. The national standard by the accrediting body is 1-4. Okay, that's the standard. That's what CMS allows. That's what TRICARE allows. What the VA allows. All agree on 1-4. In all the states, I have actually this copies if you want to look at them with their state code identified. What they actually provide. And in all of the states, but 2, there is a 1-4 ratio, okay? As was mentioned, South Carolina, there are 2 states that have a 1-2. There's one state that has a 1-2, one state that has 1-3, okay, just south of us. And actually 2 states south of us, one just south and one south of that one, have 1-3. One of them has 1-4, that will allow 1-4 in emergency situations. So there's some changes in every state law that allows it. There's all but 2 states allow 1-4. Some of them only, there's a couple of them only under emergencies. There's a bunch of changes as well when it regards to students, and we're not dealing with students here. We're dealing with AAs. Okay, so virtually every state. The only one that was mentioned, there was one mentioned that the data that I got from Senator Hutchins and the data that I got from the folks that regulate the anesthesiology practice, or not regulate, but the association. There was one state was in conflict, but other than that, they were all 1-4. And frankly, half of these 1-4 were actually set by legislation. The other half of the states actually let the board decide. And frankly, I'm not opposed to a future amendment that strips out the number and just lets the board decide that here in Wyoming. But I would prefer not to over-regulate compared to all the other states, and stay to 1-4 instead of going to 1-2. So on and against the amendment.
Thank you, Senator Pappas. The question is on the Committee of the Whole Amendment number 1 to Senate File 104. Further discussion. Any other questions? All those in favor of my apologies, Senator Bouchard.
Thank you, Mr. Chairman. I do want to add that
It's actually the CMS standards that allow for, just in case for clarification, because so this isn't just arbitrarily a national board that's doing it. It's actually CMS standards allow for billing standards and their health standards. Thank you.
Thank you, Senator. And again, I apologize for overlooking. Any other questions? Further discussion? All those in favor of Senator Hutchings' motion to adopt Committee of the Whole Amendment number 1 to Senate File 104, please say aye. Any opposed? No. Committee of the Whole Amendment has failed. We are back on the bill. Anything further on Senate File 104? All those in favor of Senator Baldwin's motion that when the Committee of the Whole rises to report to do so with a due pass recommendation on Senate File 104, please say aye. Any opposed? No. Senate File 104 has passed Committee of the Whole. Senator Pappas.
Okay, the next file for your consideration is Senate File 138. Would the reading clerk please read in the bill?
Senate File 138, School Board Trustees Party Affiliation, an act relating to ballots sponsored by Senator Ellis, was referred to Committee number 4, which returned to committee recommendation that it do pass. Ayes, Senator Beitman, Ellis, Salazar, and Scott. No, Senator Rothfuss. Senator Scott, Chairman.
You have heard the reading of the bill. What is your pleasure? Senator Scott?
Mr. Chairman, I move when Committee of the Whole rise and report to do so the recommendation that Senate File 138 do pass, and I yield to Senator Ellis for an explanation of the Senate file.
Senator Ellis?
Thank you, Mr. Chairman. This is a very straightforward bill, and you'll see that it's contained within Title 22-6-130. And this would allow your school board trustees, when they run for office, at their option and discretion to include their party affiliation. And so just a little bit of background about the bill. Before being elected to the legislature, I would do my due diligence, try and learn about the candidates as much as possible. But inevitably, when it came time to vote for trustees for the local school boards, I often looked at the list and didn't know who the individuals were. And as you look online, it's oftentimes difficult to find websites and other information about the backgrounds of these individuals. Since being in the legislature, however, I've learned a lot more about my local school board candidates, and I've found myself in a position of becoming somewhat of a clearinghouse amongst my friends. Right before the candidate season, and people are going to vote, they ask me, who are these people? What do they believe in? And, I think we're really doing the public a disservice by not providing more information about candidates. In looking at races in my district in particular, there were a number of candidates who spent $0 campaigning, $0 fundraising. And while that might seem charming, to me, that seems a little alarming because, clearly there's not mailers being sent out explaining priorities or positions, philosophies on governance. And so this bill at its most basic level, Mr. Chairman, allows the voter a little bit of information, but it's left to the school board trustees' discretion. So if a trustee wants to communicate their party affiliation, they can, and that can communicate to voters their general position on maybe specific education issues or governance. But I also thought it was important to recognize that not all people fall in those categories. Some candidates don't view themselves through any particular lens and maybe want the option of remaining nonpartisan or unaffiliated. So rather than forcing candidates to put their party affiliation, this is an optional bill. And beyond that, I look forward to our discussion, but I just think this will help increase some transparency about who these candidates are and give voters a little bit more insight into their political views. Thank you, Mr. Chairman.
Thank you. Anybody else? We do have a standing committee amendment. Oh, excuse me, committee of the whole amendment. Senator Guru, do you want to? Do I have it read in first, please? And then you can present it.
Senate File 138, Committee of the Whole Amendment Number 1, page 1, line 14, delete.
Committee of the Whole Amendment number 1 to Senate File 138 and ask for your favorable consideration. Mr. Chairman, members, I don't know if I agree with this bill or not right now, but this is an attempt to make it a better bill. If it's a good idea to list our party affiliation when we're running for school board, then why not just do it? Why, I don't understand the part about making it optional. If you want to put your, if we're going to make that a party office, let's make it a party office. If we don't, then think we've done pretty well with it being a nonpartisan office up to now, just like our city council and other nonpartisan offices, but I'm willing to swing with a good bringer of the bill, but let's just do it. And so that's what this does. It says that you will put your party affiliation down and that you should. So that's the essence of the amendment, and I urge your favorable consideration. Thank you.
Any discussion on the amendment? Senator Ellis.
Thank you, Mr. Chairman. Certainly in bringing this bill, that was something I contemplated. And just for the body's awareness, there are some states that have made their school board elections partisan races. And, this would be somewhat novel in our country, to my understanding. I'm unaware of any other state that has the option. However, I think that, in working on this bill and just kind of thinking it through in my preference, I do think that there are candidates out there who view themselves as apolitical. And so I do want to respect the rights of those individuals. So it's a policy call by the body, but I just wanted to make that known that this is a bit of a different approach. But something to think about, we talk about these offices being nonpartisan, and I don't know that I agree with that. I think that anyone who's been involved with quote unquote nonpartisan offices often realize that the people who serve in those positions are passionate, they have political beliefs. And so not always, but in some instances, I just think giving the candidates the option might make this more palatable. And I think if we make it mandatory, we'll see more resistance and probably seeing the bill's failure. But one other thing I did want to mention before leaving this topic is, just to be clear, this wouldn't create a runoff. These elections are all, top vote getters. And so really nothing of that would change. The, effect would be more or less just how your name is printed on the ballot. And so that, I just want to make it clear, this wouldn't add an additional runoff election to these races. Thank you, Mr. Chairman.
Okay, any further questions on the amendment?
Question.
Okay. All those in favor of, oh, yes, Senator Guru, I didn't see you.
Thank you, Mr. Chairman. I've heard tell that there is a party called Independent that's available as an alternative. If one of the partisan parties doesn't suit your personal political views, then maybe you could go that way. But the bottom line is, like I say, what's good for the goose? So I say, if you want to make this a partisan office, make it a partisan office. Don't waffle, don't equivocate. Let's do this. On and for the amendment. Thank you, Mr. Chairman.
Okay, are we now ready for the question? Okay. All those in favor of Senator Guru's motion to adopt Committee of the Whole Amendment number 1 to Senate File 138, please say aye.
Aye.
Those opposed, say no.
No.
The chair is undecided. Let's have a standing vote.
There we go.
All those in favor, please rise.
That's not such a good idea.
Thank you. Please be seated. All those opposed, please rise. Okay, the yeses have it 14 to 13. The amendment has passed. We're back on the bill. Senator Rothfuss.
Thank you, Mr. Chairman. Even with the amendment on and against, Mr. Chairman, you know, when I look around the country right now, I look around the state, I look around at the state of affairs, the last thing that comes to mind is, boy, there's just not enough partisanship. That never strikes me. If only we had more knowledge of who was which party, we would be able to get things done. We just had an election. It was an election that I don't think any of us really want to revisit in terms of the acrimony that we saw on many occasions. And we had a pretty significant number of school board members that were turning over in my community. I still don't necessarily know which party they were in, the folks that I voted for. I read their bio statements, I read their profiles, I read what they thought about education, I read their backgrounds, I read as much as I could, and the information was available. It's true, Mr. Chairman, I had to work for it. It was not written on the ballot. That is accurate. They did not have their bio sketches below their names in the ballot. So I had to look into it myself. But I'm actually pretty happy that I don't know what political party they're from. That's good, because I don't want the basis of my kids' education to be partisan. I don't want that to be the driving force. I'd like it to be based on what's best for education. And it would be great if somehow there were a perfect division between the parties where my educational philosophy was perfectly in line with one, and that somehow that would be a magical outcome. But I think we know in this chamber that it's actually more complicated than that a lot of the time. That R's and D's are not the end all be all in how we should value humans, and which one more closely aligns with all of our beliefs, particularly on a specific and specialized issue like education. So I understand the desire to have more information. I understand the desire to have a better informed public. I actually think we get less of that with the R's and D's. If anything, I'd rather see the ballot not have them on it. You have to go out and do work. Go find out for yourself. Fend for yourself and learn the names. Figure out who they are. And I think we'd probably get better elections, better outcomes, a more informed voting populace if we were to go that route. But obviously that's not before us. What we have before us is a system that has avoided to some degree, and it's true, it's not perfect. It's not completely apolitical. We all understand that. But it's at least attempting to avoid the politicization of education in a way that would probably erode the quality of the system more often than it would help it. In my district, in my county, if we had R's and D's, we'd probably just end up with a bunch of D's more often than not. In other counties, we'd probably end up with a bunch of R's. It doesn't matter whether they were expert. It doesn't matter whether they were the best choice. You'd get those because it's the easy result. When you just have a random list of names and you show up and you don't know any of the names and you haven't done the research, your vote's pretty much random. You pick the name you like, maybe the top one. We know that's slightly biased. And what happens in that circumstance is it empowers the folks that did the research and looked into the reasons why they would be voting. Those are the ones that are capable of delineating among the candidates. The system we have now empowers the informed voters and disempowers the folks that didn't take the time to look into it. Switching through this bill would empower the folks that didn't take the time to look into it to just cast kind of the lazy, uninformed vote, but for somebody that shares their political affiliation, which may or may not be the best vote because they may or may not be the best for that specific position. On and against the bill, let's try and depolarize, depoliticize, and reduce partisanship instead of moving in the other direction. I hope we can do that, Mr. Chairman. Thank you.
Senator Case.
Mr. Chairman, thank you very much. I've been thinking about this too. There's nothing that prevents people from running for school board on a partisan basis. I mean, not officially on the ballot, but you can certainly say that you're of a particular party. You stand by those principles. Support me because I'm a member of the Libertarian Party or the Republican Party or the Democratic Party or the People's Party or the Blue Party. Nothing stops you from doing that. You can put it on your campaign literature. You can, you can seek the endorsement of the central committee of whatever that particular party is. You could, work with it. Nothing now prevents that from happening. People don't tend to do that I'm aware of. I wonder why.
Senator Scott.
Mr. Chairman, on and for the bill. This was a bill, I guess, a lot of the time each of us vote the situation in our district, our constituency. And that was my case in this bill. In our community, the problem is not partisanship or lack of partisanship. The problem is no choice at all. We're having trouble getting people to run for the school board. And I thought that there's a possibility, if we start identifying them, maybe the two parties will start recruiting some candidates and give us a choice. That's one of the things that the parties do and historically have done in this state. So yes, it's a step down the road toward having a party affiliation, but it might also be a step down the road to giving us some choice, because that's our problem. Now, I don't know how that plays out in all the districts around the state. That's not apparent. And this is just a small step. It's not a full partisanship. But that's why I've supported the bill in committee and voted for it, is I think it might help giving us some choice where we haven't had any recently.
Senator Ellis.
Thank you, Mr. Chairman. Great discussion, all great points. I just want to push back on this notion, though, of the lazy voter. What about the lazy candidate? If I'm not nothing, it's thorough. And I can promise you, I was not a lazy voter. I looked at candidates. I tried Googling their names. I looked for websites. I got on social media platforms, looking for information. I could even find phone numbers that I could call. And so I think the reality of this isn't just a one-sided, oh, these voters are lazy. It's a transparency issue. And so, like I said, that's why I brought the bill as an optional form, trying to preserve some of that partisanship. If a person doesn't want to be involved in that, being recruited by a party, seeking endorsements, they wouldn't have to. I can tell you in my county, though, there's a huge reluctancy, if not complete inability for our party to endorse nonpartisan races. I know that that's been a conversation topic for our party, but it's something we haven't done. And so for me, this isn't about protecting lazy voters. It's about encouraging candidates to be more proactive with getting information out to their voters on where they stand on these issues. And this notion that it's going to somehow increase partisanship, I see partisanship and a polar divide in my school board now that I've had a closer look at it. And the unfortunate thing, though, is the public doesn't know about it. Now that I've spent some time looking at how our board operates, attending some of their meetings, I definitely see divides on certain issues, and they're not all, Republicans versus Democrats or one party versus another. They're more dynamic than that, much as the dynamic is in this body. But I think it's giving the public an opportunity to kind of peek behind that a little bit more. And so that's why I'd encourage your vote on this bill.
Any further discussion? Senator Hicks.
Mr. Chairman, on and for the bill. And I think my colleague from Albany County brings up a good point. Is when you have a list of candidates there, and you may not have had the opportunity to go through and understand their position on everything, but affiliations matter. And you have to ask yourself, Mr. Chairman, why do people affiliate? Is because we share a like belief or a like philosophy. We belong to different organizations because we want to affiliate with those people because we share something in common. So when you have a slate of candidates there and you're not sure, the one thing you can be sure about is if you do have some level of party affiliation, you know that right off the bat that there's going to be some philosophical things that you believe in because you chose to affiliate with these people by identification to an organization that they belong to. It helps make informed consent for those people who haven't done all of the hard work and the detail to understand every single candidate's position on every single issue. Mr. Chairman, I would argue this actually helps provide informed consent when you have a choice and you don't know out of a group of 3 people what those positions are, but you know what they affiliate with and to a certain degree what their philosophical beliefs are. I think this helps provide informed consent under those circumstances. Mr. Chairman, on and for the bill.
Any further discussion? Are you ready for the question? All those in favor of Senator Scott's motion that when the committee of the whole rises to report that I do so with favorable recommendation of Senate File 138, please say aye. Aye. All those opposed say no. Senate File 138 has passed the committee of the whole. The next bill for your consideration the Senate File 149. And let's see. Yep, no amendments. So Senator Anderson. Oh, yes. Excuse me. Will the reading clerk please read in the bill?
Senate File 149, Oil and Gas Royalty and Tax Rates, an act relating to oil and gas, sponsored by Senator Boner, was referred to Committee Number 9, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman.
Thank you. Now, Senator Anderson, you have the floor.
Mr. Chairman, I move that when the committee of the whole rise to report, do so with the recommendation that Senate File 149 do pass. And to explain the bill is Senator Boner on the screen.
Senator Boner, you have the screen.
Well, thank you, Mr. Chairman. Yeah, hopefully everybody can hear me. Ladies and gentlemen, what we have here is Senate File 149. Basically, it adjusts the severance tax rates for oil and gas on federal land, depending on what the actions of the federal government may be upcoming. So as we all know, ladies and gentlemen, oil and gas is going to face some challenges moving forward. In fact, probably you could say already has faced some challenges with developing on the federal nexus, whether that be the actual federal land or federal minerals. And there's lots of potential areas of challenge when it comes to developing on these on this land. Part of it is regulatory, a significant portion is regulatory, I should say, and that if the objective of the federal policy is to inhibit or to discourage production on federal lands, they can make all sorts of red tape that you have to go through in order to accomplish that economic activity that we depend on so much for our livelihoods in this state. But also there's an opportunity to raise the royalty rate, which has been discussed publicly, and there's a distinct possibility that that royalty rate could be going up before this legislature has an opportunity to meet again next year. So what this bill does is simply states that if the federal government raises the royalty rates for oil and gas, that the state of Wyoming will reduce the severance tax. For every 1% the royalty rate goes up, we would reduce 0.5% of the severance tax. The idea being that since the state receives 48% of
Hi, Nicole. This is Nikki calling from Solidarity Health Share, returning your call from last week.
Pardon me, Mr. Chairman. But the idea being that since we do receive 48% of those federal mineral royalties back, it would be revenue neutral to the state. So that's the idea. This is something that we could do to make Wyoming more competitive as the federal government seeks to make us less competitive, and do so in a way that does not negatively affect our budget. Once again, it's not a full way to completely make up for any increases in severance tax, in royalty rates, but it is a way that we could help out for every 1% the royalty rate goes up, that the half percent will reduce on that severance tax. So that's the basic idea behind the bill. It's a fairly straightforward concept. It's one that I think is important moving forward to demonstrate to everybody that Wyoming's open for business, especially in such a vital industry as oil and gas. And we're going to do what we can to support this industry in a way that is not going to negatively affect our budgets. So that's the bill, Mr. Chairman. July 1st effective date with emergency rulemaking. I'd certainly stand for any questions.
Thank you. We're on Senate File 149. Any discussion? Senator Case.
Thank you very much, Mr. Chairman. I would urge a lot of caution here. We have studied reductions in our mineral production taxes before. We've studied it on 2 occasions, most notably a couple of years ago. In both cases, we found out what really drives the exploration and development of our minerals in Wyoming are the quality of the resource and market factors. They're not the taxes. And there's been some land breaking work that's come out about this. I fail to see why we should follow and do the opposite of what the federal government does, because it won't change the outcome. If we leave our rates where they are and the feds change theirs, we will be in better shape than if we remove ours and try to follow and go in the opposite direction of what the federal government does. This is a bad idea. It's been documented. It didn't come through the Revenue Committee. It came from the Minerals Committee, which of course, minerals are under impact. There's no question, but this won't save the mineral industry. It won't make us better off in the long run, and it won't help the future people of Wyoming who these minerals belong to. Thank you, Mr. Chairman.
Further discussion, Senator Hicks.
Yeah, Mr. Chairman, just real quick, and I'm looking at the fiscal note when this bill was originally drafted, but do we have any updated information as a result of the 1% increase in the federal royalties? What that would do to the state's revenue stream if we reduced ours to 0? Do we have any more information than from the time the bill was drafted on the impact of that?
Any further discussion? Senator Boner, do you have that information?
Sure, Mr. Chairman. First of all, we're not reducing the severance tax to 0. It's extremely unlikely that we would see it reduced to only the 1.5%, percent constitutionally mandated severance tax. That's extremely unlikely. And like I explained before, the fiscal impact of the state is minuscule. If there's an interest in making it so it's perfectly revenue neutral, so that we reduce it by 0.48% instead of 1.5%, that's something we can entertain on second reading. But just to be clear, we're not reducing it to 0, and so it's meant to make us more competitive. At some point, I guess we can have a study that verifies all of our points of view. But if you're looking at a significant increase in the royalty rate, this will help. Right now, that royalty rate is 12.5%, which is below our state rate of 16 2/3. But I can tell you that the red tape is so significant when it comes to developing on federal minerals that even with that lower royalty rate, it's really, operators still look to avoid that federal nexus just because of the regulatory burden that goes along with developing on these minerals. So I think that, this does help. Once again, I guess, I don't understand necessarily the pushback here, because it is very close to revenue neutral. So the numbers that I ran, and please understand these are just my numbers, but for every 1% we reduce the severance tax, or every 2% the feds increase the royalty rate, it'd be about a $2.9 million loss to the state of Wyoming. Like I said, if we want to make it so it's perfectly revenue neutral, that'd be an easy second reading amendment, something that I'm very open to. But just want to verify that and reinforce that this is not going to be detrimental to the state of Wyoming, and something we could do to help out a very important part of our industry.
Thank you, Senator Case.
Mr. Chairman, it's not revenue neutral. No matter how the feds change their royalty rate, If we don't change ours, we're better off. If we don't change our taxes, we are better off under every scenario.
Any further discussion? Sensing we're ready to vote. All those in favor of Senator Scott's motion, no, excuse me, Senator Anderson's motion, that when the committee of the whole rises to report that it do so with favorable recommendation of Senate File 149, please say aye. Those opposed say no.
No.
The appears to me that the noes have it. We need to do a standing vote. Pursuant to Senate Rule 6.5, having failed to stand.
Not yet.
No, we haven't done that yet. Yeah.
Let's have it first.
So all those in favor, please rise. We'll do that first. Thank you. Please be seated. All those opposed, please rise.
Point of order,
Okay.
did you get Senator Hutchings? She rose late.
Okay, the standing vote has failed. So pursuant to Senate Rule 6.5, having failed a standing division vote, a roll call vote is required. Chief Clerk will please call the roll.
Roll call on Senate 149. Anderson? Aye. Aye. Baldwin? No. Beitman? Aye. Boner?
Aye.
Bouchard? Aye. Case?
No.
No. Cooper? Aye. Driscoll? No. Ellis? Aye. French? Aye. Murphy? No. Guru? No. Hicks? No. Hutchings? No. James? Aye. Kinsky? No. Kolb? No. Cost? No. Landon? Aye. McEwen? Aye. Nethercott? No. Pappas?
No.
No. Perkins? Aye. Rothbus? No. Salazar? Aye. Schuler? No. Scott? No. Steinmetz? No. Wasserberger?
Aye.
Aye. President Dockstetter? No. Closing vote. Closing. Vote closed. Senate File 149, 13 aye, 17 no.
Senate File 149, having failed a roll call vote pursuant to Senate Rule 6SA, is deemed indefinitely postponed. The next bill for your consideration is Senate File 98. Could we have the reading clerk please read in the bill?
Senate File 98, Bail Source Hearings, an act relating to criminal procedure, sponsored by Senator Ellis, was referred to committee number 1, which turned to committee recommendation that it do pass. Ayes Senators Cooper, Kolb, and Cost. No Senators French and Nethercott. Senator Nethercott, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Nethercott?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the due pass recommendation of Senate File 98. To explain the bill, I call on Senator Ellis.
Senator Ellis.
Thank you, Mr. Chairman. I'm going to explain a little bit about the background of why I brought this bill before getting into the details of what the actual bill states. I was approached during the summer from a local law enforcement and became aware of an instance where there were a couple of subjects who were arrested from stealing from a large box store. They were doing it across the country and across Wyoming. And in that instance, the courts had set $50,000 cash bail. A few days later, there were associates that showed up of these two individuals that were arrested in the court, and they had a duffel bag containing $50,000. When the defendants were initially arrested, they had $25,000 on them in cash that we believe that was stolen. These individuals had no legitimate employment, they had no assets, and they were associated with known criminals whose only source of income was theft of jewelry, electronics, and cash. And so when they started inquiring, wanting to know where did that cash came from, our courts were unaware to inquire about the source. And so law enforcement is concerned about this growing trend about using funds, cash sources that were likely obtained through illegal means. So what this bill does, Mr. Chairman, is it allows our courts, and you'll see the bulk of the bill starting on the bottom of page 1. It allows a circuit court or a district court to conduct something called a bail source hearing. And going on to page 2, it would, the purposes of these hearings would ensure that the defendant does not use or has not used any proceeds that were directly or indirectly derived from a criminal offense to use as cash, appearance bond, or other security for bail. In looking at paragraph B, you'll see some other requirements. Before entering an order admitting a defendant to bail, the circuit or district court may require the defendant to provide documentation or other evidence of the source of cash, bonds, or sureties that would be used for bail. And so then finally on page 2, you'll see that a lot of these matters are governed by rules that are set by our courts. And so this is a very straightforward and direct bill. But just wanting to touch on a few areas of concern. During the hearing, we talked about what kind of documentation could a court look at to determine whether or not those funds were derived from illegal sources. So at this time, I would like for Committee of the Whole Amendment number 1 to be read in.
Will the reading clerk please read the amendment?
Senate File 98, Committee of the Whole Amendment number 1, page 2, line 8, after.
Senator Ellis.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 1 to Senate File 98 and ask this body's favorable consideration. Here you'll see that we would add some additional safeguards by saying that those kind of records, that kind of documentation that the courts look at could include documents from financial institutions or employment records that verify income. Because certainly we recognize that a lot of families, if you're employed, there's a good chance that maybe you have some cash saved up in a shoebox somewhere in your house. Proof of employment would show or give the court reason to know that if you show up with cash for bail, that some of those funds could have been obtained from your own savings and things that you earned. Or if financial institutions, if you have a relative that decides to post your bail for you, those could be looked at as well. In addition, this amendment wants to make clear that this doesn't involve civil asset forfeiture. And so you'll see the language in the amendment that said that proceedings and orders under this section shall not alter the operation of how civil asset forfeiture occurs. And so that's the purpose of the amendment, and I'd call for the question on the amendment.
Any discussion on the amendment? Discussion? Hearing none, are you ready for the question? All those in favor of Senator Ellis's motion to adopt the Committee of the Whole Amendment number 1 to Senate File 98, please say aye.
Aye.
All those opposed say no. No. The amendment has passed. We're back on the bill. Senator Ellis.
Thank you, Mr. Chairman. Just in closing, I wanted to just kind of touch on another concern. If you look at our green books and our statutes and how our bail laws are set, they're really brief. Looking at your green books, if you were to look at this, it's really looking at sections 7-10-101 through 105. In total, it's 3 pages of your green books. And the reason we do that is we offer the court ability through their rulemaking ability to fill in some details. And so if you look at our rules of criminal procedure and how we set bail, one concern that we have is in Wyoming, we cannot deny bail for most defendants unless a capital offense is involved. However, courts have broad discretion to impose a number of conditions on defendants. And so if you look at the rules of criminal procedure, specifically Rule 46.1, some of those conditions of release are to ensure the purposes of the bail itself. We don't want defendants getting out. And if this money didn't come from a legal source, there's no incentive for them to return for trial. And so some of these conditions that are imposed are center around that question. How much is adequate? Where did those sources come from? But unfortunately, we're tying courts' hands when we can't inquire a little bit more deeply about the source of those incomes. So I just want to offer to the body that, this does afford to the courts some substantial rulemaking authority. But if you were to look at that rule, I think you would see that our courts really want to, things that they look at right now are whether or not an individual has family ties, whether or not they're employed, the length of residence in their community, any of criminal history. These are all factors that our courts look at right now when setting bail. And again, the whole motivation is to make sure that you're going to appear for your trial or your court appearances. And so this is just another mechanism and tool to make sure that a defendant who has no stake in illegally obtained money doesn't simply walk away. And it's not a denial of bail. It's rather just a further inquiry and look at where the source of those funds came from. So with that, Mr. Chairman, I'm happy to answer any questions.
Any questions for the Senator Nethercott?
Thank you, Mr. Chairman. Against the bill and voted for it in committee. A couple things of note here. One, the Supreme Court and the Rules Committee for the Criminal Rules recently did a complete rewrite of our rules associated with bail and bond, recognizing the fundamental need as part of criminal justice reform and as part of the need for effective assistance of counsel for the defendant to be able to do that. A complete rewrite was done, recognizing the Constitution applies here, which is the 8th Amendment, which is the right to bail. A lot of work has been done on this front. These bail source hearings derive from the federal courts, which is where they're commonly used. They're not common in state courts, and they're certainly not common, nor do I think necessary in our state. Of note, I don't believe that our judicial system is in a position to manage this on their caseload and on their docket. One, as you might recall, the public defender's office is obviously facing financial shortages and time. And one of the work that the Joint Judiciary did in previous years that this body has heard is the standards associated for who qualifies for a public defender. And we worked on some efforts to change what that affidavit of indigency looks like to see who qualified. But as we've discussed before, and what I hope to do in the future is understand what check and balance mechanism is in place to ensure that who fills out that affidavit for indigency actually does indeed qualify. The courts aren't even in a position to verify that information. So there's no system in place because there's no time, there's no ability to even determine that, whether, regardless of a bail source hearing. It's important to understand that the one crime that was brought forth in this jurisdiction was unique and rare. That defendant was convicted. The feds swooped in and took the case. He's currently been sentenced. And so there was no concern really brought by this issue. Secondly, is a standard of proof. What standard of proof does the court apply? What standard of proof should the court apply? You have Fifth Amendment issues that come forth in this hearing that really, I think, allows for significant mischief on the part of the prosecutors to have a bail source hearing to really make a second inquiry into the defendant who is likely charged with a very serious crime, to really use it as a discovery tool as opposed to concerns about whether or not the defendant will return for court or safety. So, with that, I'm against the bill and believe that there's significant challenges to it, primarily regarding our judicial resources and the expenditure of those.
Senator Perkins.
Thank you, Mr. Chairman. Mr. Chairman, about the bill, I mean, over the years, I've had lots and lots of clients who deal only in cash. And quite frankly, what is the state's business of knowing where the money came from? Over the years, the purpose of it is to produce, is to help assure the reappearance at future bail hearings. And I would suggest that a $50,000 bail is a plenty, whether it's ill-gotten gains or not ill-gotten gains, is a lot of incentive to appear at a hearing. But just to give you an examples of legal issues that people have had, oftentimes when I have people who are in significant creditor trouble and they ask what to do, I tell them always deal in cash, because it's really hard for creditors to catch up with you and get your cash. I have people who don't trust banks and they deal in cash. I've been to a number of safety deposit boxes with individuals to assist them, and they open it up and it's full of cash. It comes from selling houses. It comes from physical gold that they've converted into cash. It comes from all kinds of things. And now we're going to make people disclose where their cash came from. I'm a libertarian on this one. Thank you, Mr. President.
Senator Rothfuss.
Thank you, Mr. Chairman. I have concerns which are similar, and it really comes down to the A paragraph that we see under the new 710-107. And the way I interpret this is it would be a requirement for the courts, and we already heard about the workload that would go into it, but if we assume that they can do the work that is necessary, it seems that we're tasking the courts with deciding the guilt of the defendant prior to bail, effectively. Right? If they conclude that this individual is guilty of a crime, then they exclude money and then they set the bail accordingly. If they somehow find that there's not sufficient evidence, then all of a sudden they can do things differently and utilize the dollars. And the idea that we would put the court in a position to effectively rule on the guilt of a defendant before even issuing bail, that riles up the libertarian in me, much like the good senator from Natrona County. So I share those concerns. Thank you, Mr. Chairman.
Senator McEwen.
As we're talking constitutional amendments, this violates. I think we've left the fourth out also. Just because I show up with a pile of cash, is that probable cause to investigate me? I mean, if you show up with $50,000, I think you should have a crime that was committed where $50,000 was taken and you were in the area or something before you should even be looked at. Thank you, Mr. Chairman.
Senator Ellis.
Alrighty, Mr. Chairman, let's talk a little bit about the rules that exist on the books right now. As I mentioned, in our statute book, we don't overly prescribe a lot. We say, courts, this is your area of expertise, write some rules and get it right. And so if you do spend some time reading Rule 46.1, all of these questions and concerns that you raised are kind of issues that we're talking about and grappling with now. This isn't rewriting something grand. These are all concepts that are already in our existing rules. When we talk about the presumption of guilt, the rules say in 46.1, presumption of innocence, nothing in this rule shall be construed as modifying or limiting the presumption of innocence. However, the rules also say that if we're going to let you out on bail, keep in mind, these are people who our law enforcement have taken into custody and taken to a jail because they believe they committed a major crime. Already in our rules, it says the burden of establishing that a defendant will not flee or pose a danger to any other person or the community rests with the defendant. This isn't about assigning guilt or innocence in a trial. That's what the trial's for. This is about setting bail. I think most of us would agree that just stepping back on this notion altogether, suppose you have two individuals who rob a bank. One of them gets away with the cash, but the other person gets caught. Is it fair in your gut for that person to take the stolen money from the bank to get his buddy out of jail? I think most people, in my view, the answer is no, that doesn't seem fair. So are these considerations possible to be taken into consideration? Absolutely. If you look at Rule 46.1 and other circumstances, the whole purpose of this, of having a bail, is to reasonably assure that the appearance of the person will show up in court. And so the factors they look at are they maintaining employment? Are they working on obtaining an educational degree? Are they going to abide by other restrictions? When you're on bail, courts can set all kinds of conditions for bail. They can tell you not to drink. They can tell you who that you can or can't hang out with. And so when you talk about conditions for bail, that's what's in place right now. This is just allowing courts a deeper opportunity to look at the source of revenues when questionable individuals who have no ties to communities and whose crime, involves large sorts of cash to make those inquiries, to make sure that we're not allowing stolen items to be used to be posted for bail. And the reason this is important is because if you are an individual who worked for $50,000, I have no doubt in my mind that that money means something to you. Are you going to show up for your court appearance? Absolutely. That's a year's salary for a lot of people. But if you stole that money or your associate stole that money, what's 50,000? It's just another opportunity to have to commit another crime. If you want to look at the crime as work, that's the incentive. And that's the reason we have bail, is to ensure that you're going to show up for your court appearance. So if it's stolen money and it doesn't really mean something to you, and you didn't quote unquote work to get it, you stole it, the incentive to show up for your trial simply isn't there. And so that's what this bill allows us to do. And, you know, I push back a little bit on the workload of our courts. We heard a prior speaker say the case involving the theft of items and the $50,000 cash bail was a rare circumstance. Great. I hope that that's true. But I think we're starting to see, certainly in larger cities in Wyoming, like mine, more and more of these kind of cash intensive situations where people are showing up with duffel bags. And so the question is, are these instances rare, or are they going to happen with every case? And so if they're rare, as the one I mentioned is, then certainly we should give the courts the ability to look into the source of that revenue. But if it's happening in every case, Mr. Chairman, I think that's a much larger question. I would argue that this will be used in a limited circumstances. I'd say that our courts have the ability and already have existing laws on the books to make sure that it's not being abused. But at its core, it's just that fundamental question of whether or not you think it's fair for someone to use stolen cash to get out on bail. And so I'd urge your aye vote.
Senator McEwen.
Mr. Chairman, I just heard that we're all presumed innocent in this bail process. Yet, if you've had a friend or a child ever go through it, you're actually presumed, in my mind, guilty until you prove yourself innocent. You can't drink, you can't go here, you can't do this. You have to get a blow and go put in your car prior to being found guilty. All this stuff is piled onto you, and it's all in the form of punishment. I disagree with that. And I think the last thing this body needs to do is empower more into that process to assume guilt before innocence is proven. Thank you, Mr. Chairman.
Further discussion? Being none, all those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with recommendation on Senate File 98, please say aye. Those opposed say no. The noes have prevailed. So we'll have to have a division. All those in favor, please rise. All please be seated. All those opposed, please rise. More than before. Okay, you may sit. So pursuant to Senate Rule 6-5, having failed a standing division vote, a roll call vote is required. The chief clerk will call the roll. Aye.
No.
Boner votes no. I can't hear the chief clerk. No.
Senate File 98, having failed a roll call vote pursuant to Senate Rule 6SA is indefinitely postponed. The next bill for our consideration is Senate File 112. Will the reading clerk please read in the bill?
Senate File 112, Insurance Discount for Accident Prevention Trading, an act relating to motor vehicle insurance sponsored by Senator Landon, was referred to committee number 8, which returned a committee recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator Pappas?
Thank you, Mr. Chairman. Has the bill been read in?
It has.
Oh, okay.
And you would
So
move.
Yes, I move Senate File 112 and ask the Committee of the Hole's.
Senator Pappas, maybe when the Committee of the Whole rises to report.
Oh, yes.
Yeah, there you go.
When the Committee of the Whole rises to report, that it do so with favorable consideration of due pass of Senate File 112. And for the explanation of this bill, I'll try to do it myself.
It's a good little bill, Senator.
I may not be able to get through this, but
you bet. No, you're doing well. Here you go.
Ruling from the chair.
Senator Hicks.
If not, I vote that we overrule the chair.
Well, the ruling stands. Senator Pappas.
Yeah. Thank you, Mr. Chairman. Senate File 112, just for a little background, right now in statute, there is a statute that allows for the insurance companies to provide a discount in their premiums for passenger automobile liability or collision insurance. And it specifies that you can take courses to get a discount for this insurance. In that, in the statute, it requires that the criteria be approved by the state. And so the bill here actually, the initial bill was to strike that approval by the state. Well, after we got into committee, both the insurance industry and the department say, we have no business even looking at insurance discounts. So it was agreed by all parties that instead of changing it, we should strike that whole division. So you will see that there will be a committee of the whole, and may I have that read, or the standing committee, has it been read in? Can I have the standing committee amendment read in?
Standing Committee Amendment number 1, the reading clerk. Thank you.
It's Senate File 112, Standing Committee Amendment number 1, page 1, line 2 after.
Senator Pappas.
Okay, so if you look at the amendment, it basically strikes all of section 1, which is paragraph C of 2614-105. It's basically a repealer now. So we're repealing the requirement for the state to get involved in any insurance discount. So I ask for your favorable consideration. Let's get out of that business.
Thank you, Senator Pappas. Any questions on Senate File 112? Are you ready for the question? All those, we do have to deal with the Standing Committee Amendment. All those in favor of Senator Pappas's motion to adopt Standing Committee Amendment number 1 to Senate File 112, please say aye. Any opposed? No. That the Standing Committee Amendment is passed. We're back on the bill. Anything further on Senate File 112? All those in favor of Senator Pappas's motion that when the Committee of the Whole rises to report it, do so with a favorable recommendation on Senate File 112, please say aye. Any opposed? No. Senate File 112 has passed Committee of the Whole. Senator Pappas.
Next bill for your consideration is Senate File 127. With the reading clerk, please reading the bill.
Senate File 127, Wyoming Learn While You Earn Program, an act relating to education sponsored by Senator Kinski, was referred to committee number 4, which returned a committee recommendation that it do pass amended. Ayes Senators Beitman, Ellis, Rothfuss, Salazar, and Scott. Senator Scott, chairman. Was re-referred to committee number 2, which returned a committee recommendation that it do pass. Ayes Senators Guru, Hicks, Kinski, Perkins, and Steinmetz. Senator Perkins, chairman.
You've heard the reading of the bill. What is your pleasure, Senator Scott?
Mr. Chairman, I move with the committee of the whole rise and report to do so with the recommendation that Senate File 127 do pass. Mr. Chairman, there was a standing committee amendment, but I think we'll handle that better if we can have the bill explained first. So we'll do that, and then I'll ask for the standing committee amendment to be read in, and we'll move it. So I yield to Senator Kinski.
Senator Kinski.
Thank you, Mr. Chairman. Wyoming Learn While You Earn program is an attempt to adopt a, for want of a better word, I can describe as a European style apprenticeship type program, where starting very early in high school, students in the trades, career technical education can be working with an employer, receiving a wage while receiving credit for on-the-job training as well as their academic training in high school. Additionally, they have the potential in Wyoming to get college credit for that as they advance to their junior and senior year, and then hopefully moving seamlessly from that into the community college system with those credits and that training as a background while continuing to earn while they learn. The difference from some of the sorts of internship programs that we've taken a stab at in Wyoming in the past is this is intended to be grassroots. It's intended to be the employers reaching out to the school system, reaching out to the community college, saying, you know, we've got 2 or 3 students that are working in our machine shop or would like to work in our machine shop. How can we get them credit while I pay them to work? So, Mr. President, it's not a top-down kind of program. It has anticipated that we'd have fewer strings and restrictions that typically accompany things like the Department of Labor programs, which can be extraordinarily complex and top-heavy and red tape. So how it works, it's got initially a $1 million appropriation, which is just to try and get the programs stood up, get them underway, demonstrate some success, and then circle back and assess and evaluate and find how they might be more broadly funded. In, you know, going down the road, I would anticipate we'd want to be able to do that locally. Myself and my colleague that's a co-sponsor and down the hallway had originally looked at putting something in here relating to a funding mechanism. He's familiar with a program that's in a county that doesn't have a community college. And his students would like to work through a county that does have a community college district. And so we thought that by the time we got down here, we'd have a community college funding bill making its way through here. That's not the case. So to make it simple, we put a $1 million appropriation to get it up and running and started. So how it works is basically the employer, the school district, and the community college would all have to come together and put together an agreement on what are the costs that each is bearing and what the reimbursement is. It's important because in a high school class, you might have 20 students in a shop class. In a community college, you might have 20 or 30. Here we're talking about onesies, twosies, or threesies. And so that can be fairly expensive. They have some overhead costs that they're going to have to cover. So what would the employer's stake in it be? Well, if the employer has a supervisor, perhaps they have a degree, perhaps not, they are going to have to be able to meet and coordinate with the high school teacher that's assigned and the college instructor that's assigned. So there may be some time there where they're not necessarily earning a profit for the employer. Now, the employer may very well just donate that time. When I had my business, I was more than happy to have my professionals help out with community college students, and I didn't expect any reimbursement. I just thought it was the greater good of the profession. The high school itself, the high school teacher may have time that is not otherwise reimbursed under the model. And likewise, the community college system may have some time, particularly if the community college is on one side of the mountain and the program's on the other. That community college instructor is going to have to spend some boots on the time ground with the employer to become familiar with it. So, you know, the outlines of it are not real firmly established until we actually get some actual employers, school district, and community college to come together on it. There is precedent. My community college president speaks with some confidence that something can be put together based on his experience in other districts in other states. And I think other community college districts have been supportive as well. The other advantage to this is, and I think it's a significant one, it allows a greater outreach in terms of the CTE programs than is possible with just what you have in your local high school. So your local high school, you might have a welding machine, a lathe, maybe have a plasma cutter, maybe you have an entry-level CNC machine, but the employer down the street has some of these CNC machines that are $1.5 million to $2 million a copy. I know there's one company in my town that has a 7-axis CNC machine that they make parts for rockets and drilling equipment as well, 7 axes. So there's a prospect for greater exposure than just you can get in the traditional high school machine shop. There's one other aspect of this. There's a companion bill that is coming to us, we hope, from the other side, that relates to amendments to our state OSHA and worker safety programs. Because if you're going to have kids 16, 17, 18-year-old in a shop, currently that just doesn't work well with our state safety programs, but there are federal laws related to student learners that make exceptions provided our state plan is tailored accordingly. So that's a critical piece of this as well. And there's one portion of the bill where we call out that particular federal regulation. And but the real driver of it is going to be in a separate piece of legislation. So some may ask, how does this relate to Wyoming Works? Wyoming Works was similar, but it was aimed at the non-traditional student, a 32-year-old woman that's bussing tables that would like to be able to pick up a skilled trade. She tried CC right out of high school, exhausted whatever scholarship availability she had, and it allows them to go back to work. Now we're going to the other end of the spectrum, which is at the high school level, to allow these kids to start tracking into a career. So with that, let me give you a quick walkthrough of the bill, and then we can circle back to amendments and questions as well. So page 2, line 11, we create section 21-18-501, including definitions for credential, which is on page 3, which will be the subject of a standing committee amendment. Page 3, we actually create the program. The main purpose being students develop technical skill for a credential program while they're employed, coordinating with the employer who pays the student, as well as the community college and the school district. Pages 5 to 6 outline some of the specifications for eligibility, including provisions related to federal compliance. Page 7 outlines eligibility during high school and college, and then outlines that the college and the school districts can enroll high school students and that they can work together under this article. There is you'll notice on, I believe it's on page 8 or 9, it's limited to 4 semesters of high school. We will bring amendment to change that to 6 so that the right students who want to start in their sophomore year could do so. Then page 8 deals with non-credit internships. And by that, what we're talking about is there may be some students, they're not necessarily looking for college credit, but they want to work on a credential, an industry recognized credential in welding or machine tools that will enable them to walk out of high school and into a high paying job. So not everything has to be for credit. Page 10, line 18, creates 21-18-503. It spells out how the funds for the program are to be allocated to each community college and limits expenditure of the funds to just operating the program. Page 12, line 12, 21-18-504 is created. This is the program account. Now we're starting to get into all the sort of boilerplate that takes to just drive a program, how the colleges are to apply and receive funding. Page 14, 21-18-505 is created. This is a section that says nothing in the bill creates an entitlement to program funding, and the legislature can modify or cancel the program at any time. Page 15, line 6, 12-18-506 is created. The program will sunset on June 30 of 2026. No authorization for spending after this date. Unexpended appropriations will revert. Page 19, line 6 appropriates $1 million. Page 19, line 15, rulemaking authority for the Community College Commission. And then page 19, line 19, it's a split effective date, rulemaking to begin immediately, the rest of the bill, July 1 of 2021. So with that, I'd like to circle back to the standing committee amendment. And let's see, is that, would I move that or would the chairman
I'd
move that?
just soon have the chair move that. Senator Scott.
Mr. Chairman, could we have the standing committee amendment read in at this time?
Will the reading clerk please reading the amendment?
Senate File 127, Standing Committee Amendment Number 1, page 3, line 3, delete.
Senator Scott.
Mr. Chairman, I move adoption of standing committee amendment. Mr. Chairman, the standing committee amendment does two things, one of which is of at least mild substance. If you look on page 3, where we're defining credential, it really limits the program to the fields there, working fields of instrumentation technology, welding, machinist, or mechanic. The standing committee felt that was too restrictive and broadened it to just a skilled trade. That's the standing committee amendment there. It does broaden the program. On page 9, the bill cites a specific provision of the federal law we have to comply with. And we were, one, afraid there were a few more pieces of federal law we had to comply with. And second, that the feds might well change that particular numbering, and thought it was safer to just say, we're going to comply with federal law. So that's what that part of the standing committee amendment does. Mr. Chairman, I urge adoption of the standing committee amendment.
Okay. All those in favor of Senator Scott's motion to adopt the standing committee amendment number 1 to Senate File 127, please say aye.
Aye.
All those opposed, please say no. The amendment has been adopted. We're back on the file, or back on the bill. Senator Kinski.
Thank you, Mr. Chairman. I would move committee of the whole amendment number 1 to Senate File 120. Oh, could I have it read in, please?
Yes.
Sorry.
Will the reading clerk please read the amendment?
Senate File 127, Committee of the Whole Amendment Number 1, page 6, line 13, after.
Senator Kinski.
Mr. Chairman, I would move committee of the whole amendment number 1 to Senate File 127 and urge the body's favorable consideration. Folks, in your email, if you haven't found it already, there is a copy of Senate File 127 with the proposed amendments tracked, although the amendments are not huge in scope, so it's easy enough to walk through them. I'm going to jump to Senator Scott's covered his amendments. I'm going to jump to page 6, line 13. And the existing language of 13, 14, 15, and 16 would be struck, and insert in lieu thereof the sentence, be eligible for lawful employment within the United States. And this came about as a consequence of discussion with our Standing Education Committee. There was a lot of discussion about what it meant to be a permanent resident alien who meets the eligibility of a Title IV requirements. We didn't have enough knowledge to really understand federal education law and citizenship law, so we simply settled on, they urged me to bring an amendment that says They must be eligible for lawful employment within the United States, and that kind of covers all bases. The next amendment is on page 7, and that's on line 12. Currently, for the high school students, it says a maximum of 4 semesters, but there was discussion during your standing committee amendment, standing committee discussions, I think it was from industry, that there may be some sophomores that potentially could and would like to take advantage of this. And so we broadened it to 6 semesters to pick up those kids that are eager much earlier on. On page 8 is the next amendment. And on line 9, after the word program, you strike everything down and through line 17. And this is something that was brought, it was discussed in education, but it was also brought by the Community College Commission that the language we have there is making it much more difficult than it needs to be. And so what would be inserted in lieu of the language struck is simply this sentence: the community college in which a student is enrolled in a non-credit program shall include the student full-time equivalent in calculations pursuant to the funding allocation model provided by Wyoming Statute 1218-202 CI. And so it just says pick them up in your funding system the way you would any other student. If they're only there for a semester, you get about 1 semester's worth of funding credit for it. Next, I believe, is going to be page 11, line 12. We strike not later than 30 days after the beginning of each academic term to the commission. And again, this is something the Community College Commission said would be more workable if we simply say for each academic term at a date prescribed by rule of the commission. And that completes the walkthrough of those amendments, and I will stand for any questions.
Any questions on the amendment? Senator Landon.
Thank you, Mr. Chairman. Just a question on page, the reference to page 6, lines 14 through 16. Did I understand that to be targeted at our exchange students? Is that, and if not, I wonder what is the situation with the many exchange students that come to Wyoming? Will they be able to take advantage of this program? Thank you.
Senator Cost.
Thank you, Mr. Chairman. Mine's more of a congratulations and excitement for this because it's been a long time needed. The 6 instead of 4 is really important because a lot of people might say, well, how are these kids going to graduate? But you want to remember that there's a lot of education, math, reading, English, and writing, and all of that that can be obtained in those 6 semesters. And with the bill that you passed previously, this does a nice job of dovetailing into the flexible hours and the time for everything. So this is a great amendment and great bill.
Senator Ellis.
Thank you, Mr. Chairman. To answer the good senator from Natrona County's question, if you look at the initial language that was in the bill, it was being United States citizen or permanent resident. I believe this language was taken from existing statute related to the Hathaway. And we didn't feel like it was completely tailored to the needs of this bill. So that's why you'll see the broader language saying that anyone who's eligible for lawful employment within the United States. So as far as it relates to foreign exchange students, as long as they meet those requirements, I wouldn't say it's necessarily tailored for them, but would they be eligible? My answer would be yes, as long as they qualify under federal law.
Okay, Senator Kinski.
Mr. Chairman, again to my my good friend from Natrona County. The question is, how about them exchange students? And which is what Education Committee asked me. And we can't answer that. The original, what they were saying is, well, if you've got an exchange student staying at your house and they're really on fire and maybe they want to extend their stay and they want to get on the track to citizenship and they want to go to work for a local company there, are they eligible? The answer was, we didn't know, because the original language talks about Title V in federal law and permanent resident. We couldn't answer that question. So we decided to say be eligible for lawful employment within the United States. I don't know whether an exchange student meets those criteria or not. I suspect probably not. They're here on a student visa rather than a work visa, but we couldn't answer that question, so we made it more generic. But we didn't want to exclude the possibility that there might be some young person that comes to your town and they're really on fire and they say, you know, I think I really want to stay here and build a life here. Then we didn't want to exclude that possibility. So we don't know yes or no. The language is broad enough, we think, to accommodate.
Senator Cooper.
Thank you, Mr. Chairman. In our house over the past 20 years or so, we've had a lot of students come in from different places. We'll tell you where they're from, but they speak languages like German or French or Spanish or Kentucky that you don't understand any of those. But the exchange students themselves were not eligible for employment on their visas and in their programs. They all were restricted from having employment while they were here. Thank you.
Thank you. Okay, we're on Committee of the Whole Amendment number 1. Any further discussion? Seeing none. All those in favor of Senator Kinski's motion to adopt Committee of the Whole Amendment number 1 to Senate File 127, please say aye. Those opposed, please say no. The amendment has been adopted. We are back on the bill. Senator Scott.
Mr. Chairman, the testimony in committee on this bill from particularly the industry people was quite favorable. We do need more people in these skilled trades. This is a good way to get there. We did hear from representative of a labor union who pointed out they were already doing some of these things, but it didn't sound like what they were doing was near to meeting the full needs that are present. So, Mr. Chairman, this really did look like a very favorable bill. I think the decision the Senate has to make is it is going to cost $1 million with that appropriation. You've got to weigh the good the program will do, the help that'll be to our young people and to our economic development versus can we afford a new program in this particular year? So that looks to be the trade-off. But the testimony was, Mr. Chairman, it's a very good program.
Senator Anderson.
Mr. Chairman, I do think it's a very good program. Also, would like to see it go forward, but I'm thinking that we might be a little short on money. If we've got $1 million, that's only about 142,000 for the 7 community colleges. That doesn't sound like enough to stand up a program. Thank you.
Senator Landon.
Mr. Chairman, thank you. I appreciate the work that's gone into this. In the back of my mind is just what has happened to the infrastructure and framework of our colleges out there. And, you know, specific to this bill, you won't hear it from our colleges, I don't believe. But these are the very programs that are under stress. And the very programs that honestly, I can't point specifically to layoffs being specific to some of these programs, but I know it's happened. And so that's my first concern. And then the second concern, and I wonder if we could have some conversation about if we get this stood up and we get some students doing this, what kind of an expenditure are we looking at? Because it seems, I share the concerns of the senator from Natrona County that is this really going to be enough? And if this gets going, what are we looking at? And then the final piece of that is if we get it going, it says right there on page 15 that we can sunset it, that we can stop the program, but we know how difficult that can be because then we've got students on scholarship and in programs halfway through. Those are my 3 thoughts on this bill. Thank you, Mr. Chairman.
Senator Cost.
Thank you, Mr. Chairman. You know, as far as the expense, I don't even see it mounting up to $1 million. Businesses are more than willing to take these people on, and they're willing to pay them if they're working for them. They're providing the service to them. A lot of our kids in high school are working already. The only difference is, unfortunately, is right now they're not getting paid for it, which irritates me. They get their credit, but they don't get paid, and they can get paid. It's cleared through the Department of Education, but I don't see this costing the colleges or the schools money, maybe a little bit of money for the workman's comp, but other than that, I don't see it costing very much. So I don't see that as an issue. And I certainly wouldn't want this hung up because of somebody worried about that, because I don't think it'll be an issue.
Senator Nethercott.
Thank you, Mr. Chairman. Good little bill. It's my understanding that this is supported by our career and technical education colleges that are focused on providing these types of educations in conjunction with their K through 12 partners, and believe that this is a step in the right direction to advancing the successful outcomes for those students and those programs. And so excited for the additional support for targeting that age group that will be heading their way and starting them on that right path of a successful outcome for both their lives with earning while they learn and being productive members, and hopefully adding to our entrepreneurial focus for this state to help that diversification take place. On and for the bill.
Senator Cooper.
A couple of questions. Effective date, July 1st. By the time we get it stood up, that pretty much precludes the next school year. Would we be more effective to put this into effect sooner rather than later? And secondly, a question on terms. Would the summer term be a school term during this? So if the student is working through the school year and summer comes, can he continue that and continue on the program through the summer? My questions. Thank you, sir.
Senator Kinski.
Mr. Chairman, thank you. So the current bill has a split effective date that says the Community College Commission is going to begin on the rules right away. And then the balance of the bill would be effective July 1. I'd regard making them both effective immediately as a friendly amendment, although until the community college system gets the rules put together, I don't think much is going to happen, but I like the effective immediately as to both. And then my friend from the Basin country with more experience in education than I says absolutely to the summer semester. That would be workable.
Further discussion? Okay, question. All those in favor of Senator Scott's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of Senate File 127, please say aye.
Aye.
Those opposed, please say no. The bill has passed the committee of the whole. The next bill for your consideration is Senate File 28. Will the reading clerk please read in the bill?
Senate File 28, Motor Vehicles Security Interest Perfection, an act relating to motor vehicles sponsored by the Corporations Committee, was referred to committee number 7, which returned to committee recommendation that it do pass amended. Ayes Senators Boner, Case, Driscoll, and Nethercott. Excused Senator Scott. Senator Driscoll, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Driscoll?
Thank you, Mr. Chairman. I move in the committee of a whole rise to report it, do so at the recommendation that Senate File 28 do pass, and for further explanation, I ask you to call on Senator Case.
Senator Case.
Mr. Chairman, thank you. I think I'd like to have the standing committee amendment read in, if we could do that.
Reading clerk, please read in the amendment.
Senate File 28, Standing Committee Amendment number 1, page 2, line 3, strike.
Mr. Chairman, I would move standing committee amendment number 1 to Senate File 28. Ladies and gentlemen, this is a bill about perfecting the security instrument in a motor vehicle. As you might recall, if you were around here last session, we had a bill in this area. The issue is that motor vehicles, they're so expensive now. And in order for the lien to be perfected, for example, if you buy from a dealer and you have financing and there's a lien on the financing, it actually doesn't go into effect until the title is completed and filed. That's a bit of a problem because there's often a considerable lag time between when you go in with the paperwork to when the title actually gets finished up and has the lien on it. And I mean, in some cases, it's weeks. So during that time period, the person who has loaned the money, or the entity that's loaned the money on the vehicle, which, vehicles aren't cheap. Mid-range, they're the vehicles over $60,000. I bought houses for less than that, Mr. Chairman. And so they go on, and you're hung out to dry. And in theory, at least, if there's a bankruptcy that occurs or some other event, possibly, I guess, between the time that the vehicle is purchased and the lien is perfected on the title, there can be some exposure there. It's a very great concern to our automobile dealers, and it's a great concern to the Bankers Association. But when we got digging into this last year, we learned that it's just not that simple. And our wonderful county clerks kind of pushed back and said, you've got to understand that lots of times when we get the paperwork, it's not entirely in order. And you would be amazed at the mess ups in the order. So it's gone back and forth. There's been lots and lots of discussion between the clerks, the bankers, and the automobile dealers. And I can report very favorably that everybody has come together on the same page. And that's what the standing committee amendment does. And it was represented in the standing committee that this is something that everybody can agree to and makes everybody happy with the bill. And essentially what the bill does is say that the security interest is perfected when you get into the clerk's office and they stamp it and say that it was filed. Okay, not to when the title is completely finished. So the whole thing is now trying to deal with the rigmarole of getting that done. But that's, of course, it's not as easy as you think, And so the standing committee amendment, if you'll just let me run through the standing committee amendment through the bill at the same time, I think it'll become clear to you. So really all we do is you have the bill, and if you go to the page 2 of the bill, the language will say, the new language, I'm starting at page 1, and I'm just going to read in the amendment as I go. It says perfection of a security interest in a motor vehicle, in a vehicle or motor vehicle required to be titled instead of licensed, as hereinafter defined, shall occur upon the delivery of the following to the office of the county clerk in which the vehicle is located. And we actually delete from the bill lines 7 through 19. But looking at your amendment, we insert in this section lines 8 through 24. So the things are, number 1, a financing statement, a security agreement. And number 2, a properly tendered completed application for certificate of title along with a valid title of record issued pursuant WS 31-2-103. Then we jump out to a small b, and it says, this is kind of the key to the whole bill. Upon receiving the information required under subsection A of this section, the county clerk shall endorse the certificate of title to the vehicle or motor vehicle with the lien information, including the month, day, and year it was delivered to the county clerk. That's the key word, delivered. That makes it effective on that at that time. The rest is kind of cleanup, Mr. Chairman. If you go to page 3, line 15, there's a when that comes out. We'd already got the such, so we got the when next. That would be line 15. Every financing statement or security agreement pursuant to the provisions of this section or this subsection shall take effect and be enforced from and after the time the secured party delivers a properly tendered completed application for a certificate of title issued pursuant to WS 31-2-103 and the financing statement or security agreement to the office of the county clerk of the county in which the vehicle is located. And the rest are just immensely small cleanups. There's getting rid of a comma on page 4. On page 5, I'm going to read lines 14 through 17. The new language will say the transitional ownership document serves to perfect a lien upon receipt by the county clerk, period, or as as to all creditors, subsequent purchase, on and on. It's not a period. It goes on with the sentence. That is the standing committee amendment. And in fact, that's the bill. I'd be happy to discuss.
Discussion. Question on standing committee amendment number 1 to, all those in favor, excuse me, all those in favor of Senator, I believe it was Case's motion to adopt standing committee amendment number 1 to Senate File 28, please say aye.
Aye.
All those opposed say no. The amendment has been adopted. We're back on the bill.
Question on the bill.
All those in favor of Senator Driscoll's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of Senate File 28, please say aye. Aye. Those opposed, please say no. The bill has passed the committee of the whole. Senator, Majority Floor Leader Driscoll.
I request that the committee of whole stand at ease, sound of the gavel. We'll take a 5-minute break so everybody can.
Okay. Committee of the whole stand at ease.
Oh, now we're back already.
Now we're back already. Gavel snap. Hope you're done.
Okay, if the senators would return to the chamber, we'll get started. I don't have enough.
Yeah, 16.
Committee of the Whole will come back to order. Next file for our consideration is Senate File 141. Will the reading clerk please read the bill?
Senate File 141, Business Entities Representation in Detainer Cases, an act relating to civil procedure, sponsored by Senator Perkins, was referred to Committee Number 9, which returned to committee recommendation that it do pass. Ayes Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Anderson?
Mr. Chairman, I move that when the committee of the whole rise to report it, do so with the recommendation that Senate File 141 do pass, and the capable senator from Natrona County will explain the bill. Senator Perkins, thank you.
Thank you, Senator Perkins.
Thank you, Mr. Chairman. I provide for your consideration Senate File 141, Business Entities Representation in Detainer Cases. Ladies and gentlemen of the Senate, a detainer case in this context is an eviction. Generally, evictions are in Wyoming are usually done through what's called a forcible entry and detainer. So when we talk about forcible entry and detainers or FED actions, which are detainer cases, that's what we're talking about. The problem that this bill is trying to address is simply this. A lot of people a lot of our constituents own rental properties. They may own one, two, or they may own quite a few. If they own that property in their own name, they have the ability to go down to the court and represent themselves in the federal entry in an FED or detainer case. They have the right to represent themselves. However, if they've elected to have their property in a S corporation or a limited liability company, then they violate they commit or violate the rules against unauthorized practice of law if they go down and represent their entity in these court cases. So what this bill does is provides the opportunity for individuals to represent, or for individuals who are owners or officers or employees of a company that owns these rental properties, to go down into these FED or these detainer actions by themselves. Mr. Chairman, they're very formalized. You have to do very certain things in very specific timeframes. The notice requirements are oftentimes very specific. Oftentimes, many courts have forms that you can fill out that are available to do these things. So this does not change the notice requirements or I believe in any way affect the rights of the tenant, but it will provide this opportunity for landlords to represent themselves if they choose to have their properties in a corporation or most likely a partnership or limited liability company. What the bill does is simply if you go to the top of page 1, which is where we really start, you simply see that notwithstanding any other provision of law, a business entity may represent itself without an attorney. That's the change in the law. The business entity, if you go down to line 8, the business entity is represented by an owner, shareholder, member, partner, or other employee of the business entity. That's who can do it. The person representing the business entity may litigate actions on behalf of themselves without an attorney, provided that if an attorney appears, the opposing party is entitled to a continuance so they can get an attorney too. So no one's disadvantaged if the other side shows up with an attorney. The business entity on the bottom of page 2, the business entity simply in the notice has to, in addition to the other things that are required in an enforceable entry detainer action, provide notice to the court, the state bar, and other parties of proceedings that is being represented by an owner, shareholder, member, partner, or other employee of the business entity who is not an attorney. And then it just exempts this when you do this, that you're not engaged in unauthorized practice of law. And about the only restriction on this begins on line 8. And it says that in doing this, you not only do you get the property back, you can also get a judgment oftentimes for maybe property damage, or you may get a judgment for unpaid rent that's back rent. And so what this does is it limits the judgment, a judgment for money exceeding the amount specified in 121-201, which is the small claims jurisdiction. So it limits the judgment to $6,000. Over that, if you do over that, you would have to go ahead and get an attorney. Mr. Chairman, these hearings are very short. Usually, once the person is served with the notice, the tenant very rarely shows up. Usually they last about less than 5 minutes. And even if the other person shows up, then they maybe last 7 or 8 minutes. But there just are not many excuses for not paying rent, which is the primary reason that these happen. So just an opportunity to save the hardworking people and property owners of Wyoming a little bit of money in attorney's fees, and would ask for your favorable consideration, would stand for questions. Thank you, Mr. Chairman.
Thank you. Question on the bill? Seeing none. All those in favor, Senator Anderson's motion that when the committee of the whole rises to report that to do so with favorable recommendation of Senate File 141, please say aye.
Aye.
Those opposed, please say no. Senate File 141 has passed the Senate. The next file for your consideration is Senate File 121. There is a standing committee amendment. Would the reading clerk please read in the bill and the amendment?
Senate File 121, State Funds, Investments and Distributions, an act relating to public funds, sponsored by Senator Perkins, was referred to committee number 2, which returned to committee recommendation that it do pass amended. Ayes Senators Guru, Hicks, Perkins, and Steinmetz. No Senator Kinski. Senator Kinski, acting chairman. Standing committee, amendment number 1, Senate File 121, that substitute.
Senator Perkins.
Thank you, Mr. Chairman. I move the committee whole rise and report to do so with a favorable recommendation on Senate File 121, State Funds, Investments and Distributions. I would ask that the standing committee amendment be read in.
It has been.
It has been. I'd move standing committee amendment number 1. Ladies and gentlemen, it's a standing committee number 1 is a substitute bill that sanitizes this bill and this action. And what I'll do is I'll go ahead and explain actually I'd go ahead and ask for us to vote aye on that one. We'll go to the end of the explanation of the bill, which is the substitute bill.
Thank you. All those in favor of Senator Perkins' motion to adopt standing committee amendment number 1 to Senate File 121, please say aye. For those opposed, say no. The amendment has been adopted. Senator Perkins.
Thank you, Mr. Chairman. Ladies and gentlemen, there are a couple copies I believe off the table. There's a flow chart. It's also been sent to everybody's, I think, mailbox by LSO, by our LSO person back here in the bullpen in the corner, Mary Beth. So if you've got if you have that, it'll help with the explanation of the bill. When you get this, we'll just wait just a second, Mr. Chairman, and let people get this flow chart. Yeah, did she send it out by email? Ladies and gentlemen of the Senate, this bill has to do with income and distributions off various of the permanent various permanent funds and some of the non-permanent funds of that are invested and maintained by the Treasurer's Office. Is a very complicated way in which we do these things, and hopefully this thing starts to move this in a direction that's a little bit less complicated. What I'll do is start out in doing this and explaining kind of overall what this bill does. When you look at the spreadsheet, if you start to the side that has the PWMTF is on one side, and the other large permanent fund is the Common School Permanent Land Fund, the CSPLF, is on one side. As you look at this spreadsheet, what is in red is what the bill does. The things that are not in red is essentially what the law is now. And so the red is what's the changes, or what are the changes in this bill. We'll come back to this, but I'll do a quick walk through the bill and so that you understand page by page what's going on here. The bill kind of really starts on page 2. What this does in the first from the beginning on line 6 through all the way through line 15 on page 3, this credit of investment returns comes back And it really turns out that it conforms how we do this and what we've been doing with these funds and how we've been accounting for them and dealing with the income from the funds for about the last, as far as I know, last 15 to 20 years. And you'll see as we go through later on in a number of the sections deal with conforming amendments, we talk about income, we talk about interest income, we talk about dividends, we talk about other things. And so what we're doing on here over the years, particularly because of capital gains mostly, we started to deal with in the context of earnings. And so what you find in this, all in page 2 and across the top of page, and most of page 3, is we're talking about earnings. And so we're defining earnings on state funds invested by the state treasurer shall be credited to the accounts or funds as provided by law. Romanet 1 talks about interest, dividends, and rents earned shall be credited not later than the end of the second month following the fiscal quarter. Subject to paragraph Romanet 3 of this section, other realized earnings. We talk about realized earnings, we're mostly talking about capital gains as opposed to unrealized earnings, which are may have a stock that's worth, you may have a stock or an investment that you bought for $100 and now it's worth $200. If you sell it and realize that $100 gain, that's a realized earning of $100. If you haven't sold it and it's just worth that much, an unrealized gain. So we're not talking about unrealized gains. We're only talking about realized gains. So subject to paragraph 3 of the subsection, other realized earnings shall be credited as soon as practicable after the end of the year, but no later than 90 days after the end of the fiscal year in which the earnings were realized. This is just, so these are just talking about timing and when these things have to be credited to these various accounts to which this is going to apply. Romanet 3 talks about a debit against the account or fund for which a credit exists as a result of investment losses. So unfortunately, not every investment the state makes increases in value. Sometimes they decrease in value when they're sold, there's a realized loss, not an unrealized loss, but an actual realized loss. And so it recognizes that when we do this, that investment losses from a prior year's investments of the fund or account shall be paid before distributions under paragraph 2 of this subsection. What we're just saying there is that we got to make sure that we account to take care in these realized losses and kind of net them against the realized gains. And that's how we really get to our earnings. Subsection 4 provides for what we call the treasurer. We used to call it the Meyer rule, but now lately it's been called the treasurer's interpretive rule. What that happens in certain years, if there's substantial unrealized losses, the treasurer can hold those into account and you can pay those back over a period of time, netting them against the realized earnings in future years. And the reason you do that is if you have a significant downturn, you may have a significant drop in income as well as significant losses in one year. Instead of these things helping smooth that out, you actually can compound the losses and actually increase the volatility of earnings. And so that's been the way we've been doing that treasurer's interpretive policy for at least 12 to 13 years, and it just allows for that to continue. And so ultimately that we just come back, and that's what this does, is just conform what we do in these funds to the current practice, and that is what the current practice has been for, like I say, probably the last 15 to 20 years. Section 2 then starts to go down in and we do a couple things in these. We start down through the various spending policies. If you go on page 4, we're talking about spending policies and the permanent funds. Spending policies are interesting things. We talk about spending policies. If we had what was called an endowment model, the spending policy is a certain percentage that you measure against the value of the fund, and that is what you spend each year. In the state of Wyoming's case, oftentimes we talk about the spending policy, and as we go through this, you'll see we don't always expend the spending policy in the state of Wyoming. And we'll talk about that a little bit. But what you see here is that the spending policy, if you go to the middle, starting on page line 9 of page 4, the state treasurer shall transfer unobligated funds from this account, which is the Wyoming Permanent Trust Fund reserve account. All funds within it, we're just talking about the state treasurer shall transfer unobligated funds in this account to the general fund as necessary to ensure that the amount equal to 2.5% of the previous 5-year market average of the Wyoming Permanent Trust Fund is available for expenditure annually during each fiscal year. So we'll find out later that the spending policy for the Permanent Trust Fund is 5%, but the only thing that's guaranteed, the actual spending policy, is really just 2.5%, that you'll see what this bill does. Or as soon as practical there after the end of each fiscal year, beginning on or after July 1st of 2017, which is kind of when this all went into effect. Then the other stuff is this is in some of the changes that we're making. It leaves everything else at the same. And these reserve accounts have sometimes that they go in and tip. But then you go to page 5, the annual spending fall for the permanent trust fund for each fiscal year, as it says 5%. But again, all it's ever guaranteed out of this for right now is 2.5%, particularly if this bill passes. That's all it's guaranteed for right now. So what that means is unless or until earnings from the permanent trust fund equal at least 2.5%, you'll make up the difference from a reserve account. But once it's made 2.5%, it doesn't require that an additional 5% be pulled out of the reserve account. The annual, and so that finishes. You see the 5% for the permanent trust fund. Then you go to subsection H on line 13. Now we're talking about this common school permanent land fund is for each fiscal year. We just clean up that, and we just now will be 5% of the previous 5-year average, which is the same as the one before. However, there's a difference in when you go back into the other language dealing with the spending policy. It really has been. The 5% is a guaranteed amount if there's enough money in the common school permanent land fund reserve account to cover 5%. That is a guaranteed amount there. If there's not enough money in the reserve account, the 5% spending policy doesn't provide you with the ability to spend 5%. So then you go to the top of page 6. Now we're just talking about the spending policy for still a different fund. The higher education endowment is again 5%. So we see we're just making all these spending policies. We're trying to create some parallelism and treat a lot of these things kind of these different accounts the same way. So that takes us to through line 9 on page 6. Then you go to line 10 on page 6. We're back now talking about the Wyoming Mineral Trust Fund. We're making it for during each fiscal year beginning July 1st of 2022 and fiscal year 2023, which are less than the spending policy attached to this subsection are appropriated from the general fund according to this other subsection. We're going to get there in a second. So all we're doing again here is the 2.5%, any earnings in excess of the 2.5%. And again, we're back in the permanent trust fund. Any earnings in excess of 2.5% are amounts specified in this section are just simply credited. So if you make more than 2.5%, the difference between 2.5% and 5% that you make in that year are credited to the LSRA. It simply goes into the LSRA, sometimes called the rainy day fund. The change is there. It used to be split and half of it would go to the SIPA account and half of it would go to the LSRA. Now it just goes to the LSRA. And then the appropriation of subsection shall be credited to the designated account. Since it's just one appropriation now instead of 2, because it all goes to the LSRA. Then we start, and you'll see then we start down through a number of conforming amendments. We talk about the state fair endowment account. And so since we simplified this and now we're just talking about earnings, this is just a cleanup or conforming to have the earnings credited to the Wyoming State Fair account. You go to the next on line, the next one on 197401 is the Military Assistance Trust Fund. Another account, again, it's just a cleanup. It's now in accordance. So we're talking about earnings and timing of the payments from the Military Trust Fund will just be paid into that trust fund account in accordance with the same timing. You go to the High Excellence in Higher Education Endowment Fund, the Hathaway Student Scholarship. We go through those and you'll see again, you're just talking about the only changes made there at the top of page 10. It just makes it conforming so that you're now talking about earnings and you're talking about the timing of those deposits that we talked about on the very first page. Same thing on 21-2101. It's just a conforming amendment talking about instead of interest, now we're talking about earnings. On page 10, you're talking about the Wyoming Public Television Matching Program and the accounts there. Again, it's just a conforming language for earnings and timing. Game and Fish Fund, earnings. We're just conforming to earnings, using the term earnings. What we're doing is on the severance tax distribution created formula. You'll see that now instead of that shall be deposited in the permanent trust fund, period. Now what we're talking about this is the 1% severance tax account. And what we're doing here is saying that what we want to do with the 1% severance tax account is we want to take that and put 1/3 to the corpus of the permanent trust fund and 1/3 to the common school permanent land fund. The reason we're doing that into the Common School Permanent Land Fund is that approximately 1/3 of the severance taxes are paid off school lands. And for years, they've been deposited in the permanent fund, excuse me, the Wyoming Permanent Trust Fund, when they probably should have been being deposited in the common school account. So this just makes an approximate distribution about, from historically what that is, and just making those deposits to those funds. So if they go in there, will be able to be invested and generate money for both the general fund and the common school permanent land fund. Then in section 3, on those repealers, if I remember our discussion right, what those repealers are the there's the 9421, and though most of those are having to do with step downs. They step down from the spending policies are being stepped down from 5% to, I think they went to 4.25%, and then a couple of years later they went to 4.5%, and then eventually they stepped down, I thought, to 4.25%. As we've talked about in the common school permanent land, in the permanent trust fund, really the only thing that's guaranteed is 2.5%. So stepping it down is not going to change the 2.5% that's in the bill already. It would have some effect on the 5% guarantee out of the common school permanent land fund. But the other thing I would say about that is when we talk about the five-year moving average and of the value of these funds at the close of each fiscal year, when you talk about that, it has a net effect because you're averaging the funds over 5 years. It drops at about the effective rate of that. It drops at about 0.5%, between 0.5% to 0.75%. So you're really, the spending policies as a percentage of the current value of the fund are usually run somewhere between 4.25% to 4.5%, maybe 4.6%. So that's what the net effective rate of the spending policy is. Then the section 4 repeals there's a number of things we've done in the bills with these fund tips, and it repeals a lot of the fund tips that have happened in those accounts. Again, you go into the top of page 14, it takes the current OPSTA money, which is the 1% optional severance tax deposits for this year, and deposit at the close of fiscal year 2/3 into the permanent fund and 1/3 in the common school permanent land fund. Line 6, then this had to do with trying to get rid of, wasn't a part of the motion, then continue the work of trying to do away with the SIPA account. It directs that on July 1st of 2022, we talked about this in an earlier bill where we got rid of the SIPA account, that the funds from the Wyoming State Penitentiary Capital Construction Account, which is part of SIPA and which is within the SIPA account, shall be transferred to the LSRA, which is the Legislative Stabilization Reserve Account. And so it's just doubling up on something we did a little bit earlier, but putting into this bill since we're trying to put all these tips into one place. And the only thing it does is, like we talked about, allows that if there's any amounts out there, then that are for any expenses, that those will be paid before they tip back into the LSRA. So then we get down to section 7, and this is nothing in this. This is just a kind of a savings clause. Should any enactment in the 2020 general session conflict with the provisions of this act, this act was prevailed. So this is the one, if this were to pass, although we've seen some of these fund tips in the budget bill and elsewhere, and this is the one that would supersede all other acts that deal with those types of fund tips. Finally, in section 8, what this does is it directs the Select Committee on Capital Finance to study continuing to move the model of these funds to an endowment model. The benefit of looking at that is it would make it easier to understand, and it makes it easier to invest for a total return instead of splitting this up where you have to invest the reserve accounts differently than you do the corpus and some other things like that. In talking about moving that direction, if we do that, it will take a constitutional amendment. So we'd study that and look if we moved in that direction, what we would have to do to the Constitution to be able to do that. And if ultimately the recommendation is to come back and do that, then that's what the committee would be charged with doing, is coming back with those recommendations. Interestingly, if you want to know what the common law adopted, if you go to page 17 and look on line 9, the common law adopted under WS 18101 I thought that was kind of novel. I looked it up. And the common law is that we take the common law with respect to James, I think it was King James the First, excluding the Elizabeth 40 provisions of the English common law. I had no idea and I looked that up. It was kind of fascinating. But anyway, it all had to do with English common law back about the time the United States became a country. And so we're just finishing up on what they're supposed to do, looking at the prudent investor rules and all, just directing the study that the Select Committee on Capital Finance and Investments would undertake if we're going to continue to move this towards an endowment model, what would have to happen for that to take. So that doesn't, it's just a study. It doesn't do anything other than come back with a study and see if there's a recommendation to how to get more bang for the buck in these funds. These funds represent a lot of money, and I can tell you that for the year, if you look at the Common School Permanent Land Fund, the Permanent Land, the University Permanent Land Fund, Hathaway Scholarship, the Excellence in Education, the Workers' Compensation, the Wyoming Permanent Trust Fund, the LSRA, the pool, and the State Agency Fund, right this year for fiscal year 2021, total income and gains and losses year to date, realized gains and losses year to date, just right a little over $650 million. So when we do this thing, it's a big deal. It's about a lot of money. This helps, I think, provide some sanity going forward in this, some predictability, and continues to try and direct money back into these permanent trust funds and the Common School Permanent Land Fund, these other funds, so we can manage those and they'll provide for the future expenses that they're intended to provide for, all without raising any taxes. Thank you, Mr. Chairman. I'll stand for questions.
Questions? We do, or I'll entertain the Committee of the Whole Amendment. Senator Kinski.
Mr. Chairman, I'd ask the Committee of the Whole Amendment number 1 be read in.
Would the reader please read in the Committee of the Whole Amendment 1?
Senate File 121, Committee of the Whole Amendment number 1 to substitute Bill number 1, page 1, line 1, delete.
Senator Kinski.
Thank you, Mr. Chairman. I would move Standing Committee Amendment number 1, or excuse me, Senate Committee of the Whole Amendment number 1 to Senate File 121 and urge the body's favorable consideration. Folks, this is a great bill, except I have reservations about one piece of it. And that piece relates to what's commonly referred to as intergenerational equity. So we've got billions of dollars, we invest them, and a piece of that we get to spend currently, and a piece of that should flow back into the permanent fund or the Common School Permanent Fund for future generations to earn returns. And currently, the spending policy amount is 5% of the 5-year average of the value of the corpus. And that is due to step back to 4.75% and then 4.5%. And it's due to do that for a very good reason on Capital Finance Committee. And again, I've heard in the retirement board, our future earnings are going to not match what we have in the past. Going forward, those of you that look at your retirement, you know that the returns of the past bull market for the last 12 years are not expected to be what we see going forward. So it was a hard fought battle over the last several sessions to get concurrence on an agreed bill that would step that spending policy down gradually from 4.75 to 4.5%, meaning relatively more of the earnings will go into the corpus in anticipation of the fact that our earnings will be lower as well. And we did that because we wanted to be fair to future generations. So the heart of the amendment is actually, I'm going to start on page 13. On page 13, line 14, midway through the sentence, you'll see a little D, VI, and then a VII, and then an H, Romanet 6. And on the next line, you'll see 2 more provisions, Romanet 7, and then an O, Romanet 2. Those would all be deleted. And what they are is their current, what we are deleting, what the bill is repealing is current law, which says spending policy will be stepped down. By deleting these repealers, we are going to keep into place current law. So we're saying we're not going to go back to 5% spending policy. We're going to keep the law as it is, 4.75% and 4.5% to be fair to future generations. The balance of the amendment on page 1, on page 3, and on page 5 is simply strikeouts to conform with that fact that we are trying to keep in place the step down in the spending policy amount. Now, I believe that spending policy step back has already been postponed, if not once, twice. And the longer we postpone it, it means we're going to have more money to spend now, and that's coming at the expense of future generations. So I would urge an affirmative vote on the amendment. Thank you, Mr. Chairman. Stand for questions on the amendment.
Standing Committee Amendment number 1 is up for discussion. Senator Perkins.
Just on and against the amendment, and for
Committee of the whole.
a couple of reasons. One is again, I come back to the point that the spending policies have never been and aren't spending policies. We don't spend 5% of the corpus unless there's enough money in fact, we just don't, with one exception I'll get to in a minute. What we do is particularly in the permanent mental trust fund, like I said, the only thing that's guaranteed out of this bill is 2.5%. If there's up to 5%, the only thing it does is that ends up going into up to that amount goes into the earnings going to that reserve account to the extent there's anything that goes into that reserve account. And if there's money in the reserve account, you might be able to get these guarantees out. But if there's no money in the reserve account, you're not guaranteed anything. The spending policies, there's not enough there to pay. So again, the only guarantee that you have in the permanent trust fund is 2.5%. If you don't make 2.5%, if you make more than 2.5% right now, it goes in the LSRA, so it's already in savings. And if you go to this Common School Permanent Land Fund, for years that's where there was we've had a compromise with our friends that are in the building that we'd have 5%, and the 5% from the Common School Permanent Land Fund is guaranteed, but there has to be money in the reserve account for it to be guaranteed. If the reserve account runs dry, then they don't get 5%. All they can get is what the earnings are up to 5%. And ultimately that's gone. Originally this bill is much different than what it was in its original form. The other thing that I would tell you is that even because we're doing these on a 5-year average, over the last, since I've been in the legislature, every year the value of these funds has gone up. And so as we look at the 5-year moving average, the effect of that is that the 5% is of an amount that's lower than what the fund was at the end of the previous fiscal year. And so the net effect of that, we had fiscal LSO look at that. Net effect is, if you look, depending in the last 5 years, we've had some very good years lately. And so that amount has actually, the step down, the natural step down that occurs because you're averaging this over the last 5 years. But that step down is about between 0.5% to 0.75%. So when you do that, the net effect is that it's already at about 4.5%. And if you took it to 4.5%, eventually your spending policy the effective rate of the current value would be really at about 4%. And so as you talk about intergenerational equity, it's not just about saving for the future, it's trying to match. And so you're using an appropriate share now and also saving an appropriate share for the future. We do that in large part by helping to have the 1% the 1% severance tax now going back into savings and being contributed to the corpus of these accounts. And so for those reasons, I think that we're adequately protected. We always do this. We always have the ability. The legislature sets this in statute. When the permanent mental trust fund first started, the spending policy was 8%, and it's stepped down a number of times since then. I think it's an overabundance of caution and shifts it too much. And at the end, I think if this law passes, the advisors to the treasurer will come out with what it is, and what you're looking for is about a 50% chance that to balance intergenerational equity, there's about a 50% chance that you can meet these required earnings. If when we do this and that's above 50%, it means we're been a little bit too conservative. If it's below 50%, it means we weren't conservative enough. We always have the ability to adjust that moving forward. We don't know exactly what this will do, but it will change it dramatically if we can be disciplined enough to continue to put the 1% severance tax into the corpus of the funds. Thank you, Mr. Chairman.
Senator Kinski.
Mr. Chairman, thank you. And I applaud my chairman on what I think is a very idealistic view. And in the perfect world, everything that he says would come true. But we're not in a perfect world. We're in a political world. In the 7 years I've been here, I've seen how the many imaginative ways there are for this body and our friends down the hall to divert and to grab onto funding and to find ways to spend it. So my friend from Casper said, anything over 2.5% goes into LISRA, quote, so it's already in savings, unquote. The LISRA is not a savings account, it's a spending account. How many times have we heard in the course of the budget process, and it would be appropriated from the LISRA, we'll appropriate it from the LISRA, we'll appropriate it from the LISRA. The reserve accounts aren't even guaranteed because they can be reached into too. The only way to protect future generations is that money has to tip into the corpus, which is by constitution inviolate. We cannot reach into that corpus and appropriate that funding. And for that reason, we've had the step down in the spending policy to try and see that more tips over into the corpus. And I respect what my friend says, that it's an excess of precaution. I'm a cautious fellow. And we were cautious over the course of several sessions when we stepped this policy down to 4.75 and to 4.5. The statement that in effect, we're already at about 4.5% was preceded by the statement that with the booming stock market we've had. That's true because the table that he uses takes a rising stock market, which makes it appear like a lower and lower percentage is for the spending policy. But if this market turns, it's all of a sudden look like we're spending 5.5%, 6%. So I would urge caution. Let's keep the spending policy where it is now, on course to step down, to force this body to more fiscal discipline. I would urge an aye vote on the Committee of the Whole Amendment 1.
Discussion? Okay. Oh, Senator Hicks.
I think this is a classic example I'm going to vote with my friends on this amendment, and I've got some friends that are for it and some that are against it. So pick your friends carefully, Mr. Chairman.
Senator Guru.
Thanks, Mr. Chairman. Not against the amendment. Just say, trust your 5-year rolling average. I think the good chairman's right. And, I always talk about, we talk about what the markets are going to do. At the start of every year, if you watch those financial shows, I know I always do, they have those financial wizards come on and say, we're going to tell you, the next guest is going to tell you what the markets are going to do this year. If he's right, they invite him next year. If he's not right, you never see him again or her. And so I like the 5-year rolling average. It's in this bill, and I urge you to resist the amendment. I think it'd be the straight way to go down the road. Thank you, Mr. Chairman.
You ready for the question? All those in favor of Senator Kinski's motion to adopt the Committee of the Whole Amendment number 1 to Senate File 121, please say aye. Aye. Those opposed, say no. No. The chair is in doubt. All those who are in favor, please rise. Okay, all those, please be seated. Okay, please be seated. All those opposed, please rise. The ayes are 12, the noes are 13. The motion has failed pursuant to Senator Luz. Oh, just the amendment. Excuse me. Thank you. Okay, so we're back on the bill then. Any further discussion on the bill? Senator Perkins, you were raised?
Senator Wasserberger had his hand up and, but he put it down, so I don't know what he's doing.
He's there. I see him. Senator Wasserberger, please.
Mr. Chairman, I missed the vote and I would vote aye. Point of order on myself, but I would have voted aye on that. I'm sorry.
You missed the vote. Senator Case.
To the point of order, bring the exact same amendment tomorrow. It's perfectly acceptable. Bring it tomorrow. It's done for the day.
Yeah. Thank you. And the vote got missed. It's something we can't go back on. Thank you. Okay, we're back on the bill. Was there any other discussion? Question on the bill? Okay. All those in favor of Senator Perkins' motion that when the committee of the whole rises to report that it do so with favorable recommendation, Senate File 121, please say aye. And those opposed, no. The Senate File 121 has passed the Senate, has passed the committee of the whole. The next bill for your consideration is Senate File 139. Can I have the bill please read in?
Senate File 139, Community-Based In-Home Services Program, an act related to community-based in-home services, sponsored by the Senate Appropriations Committee, was referred to Committee Number 2, which returned to committee recommendation that it do pass. I, Senators Kinski, Perkins, and Steinmetz. Excused, Senators Guru and Hicks. Senator Kinski, acting chairman.
Senator Perkins, what is your pleasure? Oh, excuse me. You've heard the reading of the bill. What is your pleasure, Senator Perkins?
Thank you, Mr. Chairman. I move the committee of the whole rise and report it just with a favorable recommendation on Senate File 139. Community in-home service. We find. Oh man, you made it go away. Technology just abandoned us on this row. Anyway, on Senate File 139.
And
for an explanation, please call upon the good Vice Chairman of Appropriations, Senator Kinski.
Senator Kinski, you have the floor.
Thank you, Mr. Chairman. This bill is the content of it is familiar. You've seen it in a number of other bills, which is it's simply a bill that takes a section of statute that says shall fund and amends it to read subject to the availability of funds. It's a recommendation as the governor was going through his budget review. It came up in a number of instances where the statute says shall as opposed to subject to the availability of funds. And it was the recommendation of I guess the legal folks that we bring this series of bills. So this is one of a continuing series of inserting the word subject to the availability of funds into a variety of programs. I'll stand for questions, Mr. Chairman.
Questions? Seeing none, all those in favor of Senator Perkins' motion that when the committee of the whole rises to report that it do so with a favorable recommendation on Senate File 139, please say aye.
Aye.
Those opposed, please say no. Senate File 139 is passed the committee of the whole. Next file for your consideration.
Mr. Chairman, I
Majority
move the
Floor
committee of whole
Leader
rise and
Driscoll.
report.
You've heard the motion. All those in favor?
Aye.
All those opposed? The motion has carried. Mr. President. Reading clerk, read the committee of the whole report.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 81, do pass amended. Senate File 104, do pass amended. Senate File 138, do pass amended. Senate File 149 failed to pass committee of the whole and was indefinitely postponed. Senate File 98 failed to pass the committee of the whole and was indefinitely postponed. Senate File 112, do pass amended. Senate File 127, do pass amended. Senate File 28, do pass amended. Senate File 141, do pass. Senate File 121, do pass amended. Senate File 139, do pass. Senators signed, Senators Pappas and Landon, Chairman.
Senator Pappas. Mr. President, I move that the committee of the whole report be adopted. You've heard the motion. All those in favor say aye. Aye. Those opposed, nay. No. Motion passes. Mr. Majority Floor Leader. That appears to clear the desk.
Mr. President, I move we stand adjourned till 10 a.m. Tuesday, March 23. Thank you, everybody. Today was last day of Senate files. Great work. We're done at time on 5. Start on House files tomorrow.
Announcements. Senator Kinski.
Thank you, Mr. Chairman. Your Appropriations Committee, Committee Number 2, will be meeting tomorrow morning at 8 a.m. in the room W113. And we will be considering HB 133 online sports wagering and hear any re-referrals as assigned.
Thank you. Further announcements, Senator Landon.
Mr. President, your Transportation Committee's fired up, ready to go. We're going to go well into the evening with 3 House bills. We'll meet here in about 15 minutes in room W2 to take up House Bill 21, Wyoming National Guard Preference for Education. House Bill 17 engrossed range management at military training areas, and House Bill 22 engrossed Wyoming Military Code. 15 minutes. Thanks.
Thank you, Senator Ellis.
Thank you, Mr. President. Committee number 6, Travel, Recreation, Wildlife, and Cultural Resources will meet tomorrow at 8 a.m. in Capitol Extension Room W2 and online. We have 3 bills. House Bill 101 engrossed, elk feed ground closing requirements. House Bill 122 engrossed, hunting and fishing access reliable funding. And House Bill 112 engrossed, pioneer trapper licenses.
Thank you, Senator Driscoll.
Thank you, Mr. President. Your lucky committee number 7, Corporations, Elections, and Political Subdivisions, will meet tomorrow at 8 a.m. in room W110 to take up House Bill 14, right away along public ways amendments. House Bill 39, Optometrist Practice Act amendments. House Bill 38, Community-Based Behavioral Health, Priority Population. House Bill 79, Subdivisions.
Further announcements for the, okay, all the way to Senator Boner. Go ahead.
Yep, still here, Mr. President, as it turns out. So, committee number 5, Agriculture, State and Public Lands and Water Resources will meet tomorrow, March 23rd, upon adjournment in Capitol Extension Room W2 and online. We'll consider House Bill 188, Irrigation District Loans, and House Bill 229, Livestock Identification Choice Act.
Further announcements. You've heard the motion. All those in favor say aye. Those opposed, nay. Motion passes. The Senate will stand adjourned until 10 a.m. Tuesday, March 23rd.